or often counts more than anything else. So we'd say that to the extent that political reasons are on the table, that's the answer to there. Which leads me on to the next subject, which is the need for the amendment. And with less than 3 minutes to spare, the need for the amendment we deal with on the papers. I'm not going to advance that at any given length. The short point about the need for the amendment is this. If Parliament is given an unfettered discretion in the way that it currently is, then cases like this, which we say are deserving cases, will be voted down. And either it will be voted down for spurious reasons, the distinction issue which I've dealt with already, or political reasons, which we learnt about through the ANC's affidavit. And unless that discretion is therefore constrained, and you know that in terms of the relief we seek two alternative amendment relief. It's either that the first stage becomes automatic. So in other words, where a panel says prima facie case box ticked, then that must automatically go to the committee and the committee decides innocence or guilt. Or we say that Parliament must go and amend the rule to include factors, because those factors will then appropriately fetter the discretion that Parliament brings to bear when it makes this decision. So that's the amendment really in a nutshell. And then if I may just talk about remedy in the last few minutes that I have remaining, the court will know that there are, again, two alternative pieces of relief that we seek in the context of this report, resolution and decision. The one, which is perhaps the slightly more controversial one, is the substitution relief. And there, the argument against us, I see Justice Matopo is smiling, where the argument against us is that this is an unlawful breach of the separation of powers. We say that that's not correct. All the court is doing is it's using the same kind of substitution parameters that exist in other matters where the court substitutes in order to reach that particular outcome. But of course, if the court is not minded then to grant the substitution relief because of the separation of powers concern, which we say with respect is no concern at all, then we ask that the matter be referred for a de novo decision. And insofar as there might be any alleged problem with both of those issues are concerned, we've already addressed that on the papers to say that when the decision like that is set aside, the status quo ex ante is what is restored, which means that the 7th Parliament is as good as a position to determine the motion as the 6th one, because it's not the identity of the decision maker that matters, it's the decision maker themselves being in the same position to make that determination. And then lastly, on the issue of costs, we ask Biowatch. Chief Justice, those are my submissions.
Mr. Premier, when I'm not speaking, and in order to make sure that you won't try to read my facial expressions, I will look down.
I'm entirely in Justice Madlanga's hands.
Mr. Premier, I've understood the EFF's case, and you'll correct me if I'm wrong, to mean that the National Assembly's involvement should only be at the stage where the impeachment committee comes to it, that is to the National Assembly, with a recommendation. Otherwise, before that, there should be no participation at all, or not?
May I respond, Justice Madlang? Insofar as we ask for the relief about the amendment of the rule is concerned, the automatic referral from the panel to the committee, Justice Madlanga is entirely correct. That's right. Because and the reason we say that is because the panel plays the sifting mechanism. It's premature to allow the National Assembly to either up or down that vote at that stage, and that the National Assembly still retains its full rights to determine the president's innocence or guilt, both at the committee level and then at the final resolution level.
And how does that square up with what this court said at paragraph 180 of EFF 2? Let me just read.
Yes, please, Justice Madlang.
Therefore, any process for removing the president from office must be preceded by a preliminary inquiry during which the assembly, that is the National Assembly, determines that a listed ground exists. The form which this preliminary inquiry may take depends entirely upon the assembly. It may be an investigation or some other form of inquiry. It is also up to the assembly to decide whether the president must be afforded a hearing at the preliminary stage. Surely, if it only comes at the stage when there is a recommendation that says impeach, there will be no preliminary involvement by the National Assembly whatsoever.
No, Justice Madlanga, I don't read paragraph 80 in quite the same way, with all due respect. The National Assembly is still involved because, remember, the panel doesn't have an independent existence. It's not a separate Chapter 9 body, for example. The National Assembly's involvement is the adoption of the rule, which in part delegates that sifting function to the panel. So we would say, to the extent the National Assembly, in terms of paragraph 180, needs to be involved at the preliminary stage, the fact that it chooses the mechanism that it did ticks that box. What we are saying in the context of the relief that we seek, particularly the amendment relief, is that if, however, you allow that involvement to descend into the merits at the prima facie stage in the way we've articulated it in the papers, that's where the danger that is identified in EFF2 arises, because of the preemptive strike, effectively, that the majority could take against a panel report that says there's a prima facie case to answer. And I apologize if this answer is a bit long, but it's important to distinguish these things. We are saying that the National Assembly's involvement from a mechanistic perspective is not ipso facto bad, but there has to be the presence of some or other constraint on an otherwise unfettered discretion, because if you don't constrain that discretion, you get the outcome that you have here. And the National Assembly then obviously still maintains its involvement in the matter, both at the committee stage and then at the plenary stage when the resolution is voted on, as I've mentioned before.
I would have understood that the National Assembly is the full National Assembly. And if reference is made to some preliminary stage at which the National Assembly is involved, the National Assembly, qua National Assembly, not some committee of it, should be involved. I would have thought so.
Yes,
unless you want to say a committee of the National Assembly is exactly the same thing as the National Assembly.
I think I now understand the ADCJ's question to me, and I ask for forgiveness if I misconstrued it. I think where we are at odds, ADCJ, is that at paragraph 180, the court was not being prescriptive. What the court was saying is that these are the considerations that the Assembly must take into consideration when it designs whatever its mechanism is. And that's why we have the Rule 129 in the way in which we have it. What we are saying is that that rule perpetuates the very same problem that was identified in EFF2, with the consequence that even though the mechanism exists as it does, that may in and of itself be problematic for the reasons that we've identified. So we are saying that where the National Assembly chooses itself, qua assembly, to delegate that power to the panel, that's the National Assembly still being involved. Yes, the panel is exercising its independent right to determine the outcome, but the source of its authority is not something free-floating in the air. The source of its authority is the Assembly itself. And so where we are debating is whether or not the mechanism chosen enhances the principles of EFF2 or retards it. And we would say that the current design of the mechanism retards the accountability function because it allows the Assembly to have the preemptive strike in the way I've described it.
Now let's test your argument on the political shenanigans that you say a majority party would engage in to protect its leader.
Yes.
Why can't that, or why won't that happen even at the late stage that you advocate, the last stage that you advocate? Yeah, it will still happen. No, so what's the difference?
No, I fully agree. But may I answer this in two ways? Insofar as the mechanism that is chosen is concerned, we would simply say that there is, on a proper reading, a degree of fettering, but to counteract the potential of interference, the rule needs to be more explicit in terms of how it counteracts that potential for political interference. So either that it's the automatic referral from the panel to the committee, or when the National Assembly decides on the panel's report, its decision is not one framed in the widest possible terms as a discretion, but is specified in terms of factors that the Assembly itself chooses, which would limit the ability to exercise that discretion. So that's the first point. The second point then is, as this decision, as this report makes its way through the decision-making chain, what that means is the ability for the National Assembly to rely on these political reasons to vote down a report or vote down a resolution or a recommendation at the end stage is concomitantly lowered because of the proper filtering mechanism that is being played by both the panel and the committee on the proper operation of the rule. Now, I suppose in the worst case scenario, Justice Madlanga, the difficulty I have is this, is let's just say the panel did its job, it found a prima facie case to answer. By some miracle, the majority in the National Assembly said, yes, okay, send it to the committee. The committee then has a full hearing where it tests hearsay evidence, it cross-examines, it does all of those wonderful fair trial rights that it's supposed to do. And the committee itself then says, yes, we think that this president needs to be impeached. And then it goes to the National Assembly, and the National Assembly says, no, this is absolute rubbish. We are going to not impeach this president. That has no ouster effect on this court's ability to test the lawfulness of those reasons. So even if my limited application, if I call it that, is aimed only at that first leg, what happens at the panel report? If the National Assembly were to take an adverse or an opposite reason, and it was evident that there was some or other concern regarding the lawfulness of those reasons, then that would be justiciable in front of this court, as this court has repeatedly done in EFF2 and EFF1 and in a myriad of other matters where it's invalidated conduct on the basis that it's conflicted with constitutional principles. So I think it's important to disaggregate the decision as it goes up the chain to understand the fullness then of the argument that we're making. I don't know if that satisfies you, Justice Madlanga, but I'm willing to go again.
Lastly, Mr. Prema, in oral argument, unless there's something I did not hear,
yes,
in oral argument, you use very soft language that talks about an amendment or the need for an amendment.
Yes.
I'm not altogether sure whether that's an amendment that flows from a declaration of unconstitutionality of the rule or what?
Yes, it does. That we'd say is the 1721B relief that the court is entitled to give.
That's the relief flowing from the declaration of unconstitutionality.
Correct.
And just for clarity, against what constitutional provision do you measure the unconstitutionality?
Justice Madlanga, could I ask for clarity?
Against what constitutional provision do you measure the unconstitutionality? What I mean is, if you say this conduct is unconstitutional,
yes,
you will, for example, say,
yes, because
it breaches section 9 of the Constitution,
I'm with you,
for A, B, C, D reasons. So against which constitutional provision?
So let's start at the beginning, I think, Justice Madlanga, and that is from section 1, particularly 1C of the Constitution, which talks about rule of law, the rule of law obligations. And then in our notice of motion at prayer 3, you would have seen that we've identified other sections of the Constitution which speak to the duty of accountability. Accountability in and of itself is not contained in a single provision in the Constitution. I fully accept that. But what we say is, like the court has done in other matters like Glenister, where it relied on section 7 sub 2 in order to incorporate the international treaty obligations into giving a meaning of independence, we are asking this court to do the same thing, considering it's already done so in EFF2. All we're asking the court to do is to extend its logic in EFF2 to what we say is the logical conclusion. So there's no There's no single provision, but it's all of these accountability factors as has been interpreted and expounded upon by the court.
Thank you, Mr. Premier.
Thank you, Justice
Thank you,
Mandela.
CJ.
Mr. Premier.
The Premier,
Oh, sorry. Go first.
the Premier,
Justice Cheatley.
I was still checking your surname so that I pronounce it correctly.
I've been called worse, Justice Cheatley. It's fine.
Can I first make a follow-up
Yes.
on your engagement with my brother Matlanga? You were debating paragraph 180
180 of the EFF2
of
judgment.
EFF2.
Yes, yes, Judge.
Let's go back to 179 of EFF2.
$179.
Yes. The paragraph before that.
Yes, Judge, I'm there.
The first sentence,
Yes,
does it not say for the impeachment process to commence?
yes,
The assembly must
Yes.
have determined that one of the listed grounds exists. So if we adopt the approach or your invitation, or if we accept your invitation, then we would have to say we were wrong in paragraph 179.
No, with all due respect, Justice Cheatley, I'm not certain I read it the same way for the reason I suggested to Justice Madlanga, which is that even though the words obviously say the assembly must have determined, what it doesn't say is that the assembly is not permitted to outsource some of that power, and in this case to the panel to make that assessment for it, because that's the entire basis upon which the new Rule 129 comes about, because that speaks to the sifting mechanism played by a panel that is an extension of the assembly, because that's the delegated body that exercises that power.
I thought that your submission was that once the report is from the panel,
Yes,
it should not go to the National Assembly, but it should go rather
to the committee.
to the committee for
Yes.
impeachment.
Yeah.
And that's why I thought that your submission then invites us to skip the step that we said
Yeah.
it must go through
No.
in paragraph 179.
I take the point that Justice Cheatley makes, and I think that again reverts to what I said in the discussion with Justice Madlanga, that I don't read 179 and 180 as prescriptively, perhaps, as Justice Cheatley is suggesting to me in the context of what is meant by the assembly itself. Because if that were the case, it invites the necessary question about whether or not the role played by the panel is a competent role in the first place, or whether or not it's only the assembly who can undertake all of these activities. And what we would say is that EFF2 is authority for the proposition that some of that power can be outsourced to other bodies, provided that it's an outsourcing from the assembly to it and not the assembly to some other entity that's outside its control. So we would say in the current design of the mechanism, that still falls within what 179 and 180 talks to, with due respect.
Okay. I'm battling with what you submit concerning the meaning of prima facie information and sufficient evidence. And I thought perhaps the way we could do it is to do it step by step. Let's look at the text. Let's look at the words that are used
Yes.
in 129.
Yes.
My understanding is that 129 says that it envisages that there should be a substantive motion, and that if on the basis of that substantive motion there is a substantive reason, there is a prima facie case to be met, because it uses prima facie, then a panel should be appointed. But when it comes to the powers of the panel, it does not use prima facie. It uses sufficient.
Yes.
And it doesn't just use sufficient, it also says evidence.
Yes.
And perhaps I am stuck in that, because I would have thought that if something uses sufficient evidence, that shows, that is a higher threshold than when it says prima facie. So if you can just assist me.
Yes.
There. To try and show me that there is really no difference. You submitted there's no difference, but I'm still struggling with it.
I'm getting all sorts of notes, so I'm going to try and give you a sensible answer, Justice Chikri. Let me start here, please. I'm going to refer to the Magwakwa judgment, which I referred to a short while ago. And the Magwakwa judgment says the following. In relevant part, which is on internal page 16 of that judgment. It says, a prima facie case or prima facie evidence against a person encapsulates the notion of sufficient evidence to warrant a prosecution. So even though perhaps in the languaging and the context of the rule, the first use of prima facie applies as against the motion, and then subsequently, it talks about the panel needing to find sufficient evidence. We say that's sufficient information. We say that that is a species of the same prima facie evidence which runs throughout the entire rule. And that's what the panel ultimately reached in terms of its conclusion.
So are you saying that we should disregard the use of prima facie in another part of the rule and the use of sufficient evidence in the other part of the rule?
For the Magwakwa reasons.
No, I'm asking yes or no. Are you saying that we should disregard
Yes.
the fact that at a certain stage, what the rule says is that there should be prima facie. And at a different stage,
Yes.
it says sufficient evidence to show.
Yes.
So are you saying that we should ignore that?
Yes, because on the Magwakwa reasoning, they mean the same thing. They're all bundled into the establishment of prima facie evidence. That's my submission.
And you are saying we should disregard it because there's no difference.
Well, yes, and on the facts of this case, the disregarding of that is nothing turns on that, because what we know is the panel established that there was a prima facie case to answer.
Then my question then, when I was reflecting on your submissions, because that submission of yours is in your heads,
Yes.
I was wondering, what is the point then of this process? Because it seems to me then that there's a duplication. If what the panel has to determine is whether there's a prima facie information,
Yes.
and yet the motion also has to determine that, what is the point of appointing a panel?
Well, that's a fair question, but
Because they are both
Yes.
both looking at the same thing.
Yes, but that with respect is the same point. Well, let me start here. Is that
Your point is different. Your point
Yeah.
is your point is saying you should skip the National Assembly. I'm not sure, as I'm sitting here, that I agree with that.
No,
But I'm talking now about the panel and the motion, because remember, the National Assembly has received a motion from a member of the National Assembly. And that motion, what the duty on it is that it must show prima facie that there is information.
Yes.
But then you are saying that when the panel is appointed as well, all that it has to look for is whether there's prima facie information.
Justice Chikri, may I ask if you can, I don't know if you have it in front of you, but supplementary volume 1 of 2 at page 631 of that bundle, of that volume.
Page?
631. What I want to draw the court's attention to is the following. Firstly, towards the bottom of that page, around line 20, under the heading Initiation of Section 89 Inquiry. The obligation when one has regard to prima facie evidence there is at 129, bracket 1, bracket small a, which says that the motion must be limited to a clearly formulated and substantiated charge on the grounds specified in 89, and which must prima facie show the president does one of the following things.
Yes, I've looked
Yeah.
at them. I've looked at them.
Yeah.
Yes. Yes.
Sorry, Justice.
Okay. Sorry, I interrupted you.
Sorry, I'm coming to answer your question about what's the point of the panel then. If you turn over the page, once you have a prima facie motion that evidences the things in 129A, look at what happens in terms of 129B and 129C. The speaker, all the speaker does is that the speaker says, must check, and this is at page 632 at 129B, the speaker must check whether the motion is compliant with the criteria set out in 129A. So in order to get through the speaker's criteria, you have to, at first instance, when you present the motion, there must be some or other prima facie demonstration of a violation of Section 89. Once you tick the box in Section 129 of the rule, the motion then immediately gets referred to the panel. This is in terms of 129C. And then when the panel considers the rule or considers the motion and the charge, that's when the panel itself starts applying its mind. That's the first time anyone applies its mind to the content of the motion. And that's why we say that where the panel then comes to consider sufficient evidence, and this is now I'm reading at 633, page 633 in that supplementary bundle, at 129G, bracket B, must consider any preliminary inquiry relating to a motion referred to it by the speaker and must make a recommendation to the speaker whether sufficient evidence exists to show the president. And the mechanism that it does so is spelt out in the rule. It then does an evaluative exercise. So in the context of the panel applying its mind and undertaking an evaluative exercise, there is a role to be played by the panel because that's different to what the speaker does. The speaker ticks the boxes, the panel applies its mind. And then in the context of sufficient evidence being used there, we would say that that use of sufficient evidence is not different to prima facie evidence if that was used as alternative wording for the Magwakwa reasons that I've just indicated. They're all part of the same species. May I also just round out this answer, Justice Chikwe, by giving you one more reference, and that is in Volume 1, Annexure EFF1, which is the report of the Section 89 panel, at paragraph 90. Sorry, at page 90, paragraph 74 and 75. The panel says the panel answers this exact question by telling you how, with respect, they construe the meaning of sufficient evidence to be consonant with prima facie and the way that we understand it. So I suppose to sum up that very long answer in 2 points. The first one is that the panel does have a separate role to play, and that just because there's a prima facie obligation when the motion is presented is not tantamount to the same level of sufficient evidence or prima facie evidence that has to be established by the panel when it receives the motion. That's point one. And point two, that the attempt to then carve out and distinguish sufficient evidence from prima facie evidence is not a distinction at all, given what is said in Magwakwa. So those are my answers to your question.
Who takes the decision to appoint a panel?
If that
Your
would be,
reading of the rule.
that would be in terms of the rule, that's the assembly.
So they would have to have had a look at the motion, or am I wrong?
Sorry, I apologize. It's the speaker. The speaker appoints the panel. That's at 129E in that supplementary bundle of yours, Justice Chikri, at page 632.
All right, let's move on. Justice Madlanga asked you a question. I might not say it in the exact manner which he asked you. And I'm interested in knowing this rule 129G.
Yes.
From which provision of the Constitution is it crafted?
I assume it must be section 57. Because section 57 is the general entitlement of the National Assembly to determine its own rules and procedures.
Well, I'm looking at section 89.
Yes, I would say it's 57 read with 89. I would accept
89
that.
of the Constitution.
Yes.
And I think my problem is that when I look at it, it seems to embody some of the wording that is in section 89
Yes.
of the Constitution.
Yes.
And you said that the only way in which you say we must tamper with it is for the National Assembly to be skipped.
No, Justice Chikri, that's not what we're saying.
After, I heard you to be saying that after the panel.
Yes, there we are agreed. There we are
After
agreed.
the panel is considered. This.
Yes, there we are agreed.
And you say that that submission is consistent with section 89.
Yes, because what the panel does is it does the sifting mechanism, sorting out the bad cases from the potentially good ones. The committee then does the actual, so the panel does the fact-finding mission, which results in its report about is there a case to answer. The panel, the committee conducts the trial, where all of the evidential issues and everything else are tested and it reaches a conclusion. And then following the committee's recommendation, that then goes back to the National Assembly in plenary to take a decision on section 89. So how we read EFF2 is that EFF2 was the enablement of the National Assembly to not do everything itself, that it could delegate some of that ultimate power in terms of fact-finding and the trial to a panel and the committee as it did, but the National Assembly is still the body that ultimately takes the vote on whether or not the president should be impeached or not impeached. So we read that consistently with EFF2 and Rule 129 and Section 57 and Section 89.
Thanks. Let's move to a different topic altogether. The order that we are seeking.
Yes.
I wonder whether we would not be breaching the doctrine of separation of powers if we did what you ask us to do.
Well, which bit I would ask Justice Chikri, is it in your construction of the separation of powers, is it the entire order or is it specific elements of the order? I would need that clarity in order to respond.
How do you understand it?
Well, that's important because insofar as what we would say about prayers 1, 2, and 3, which is the alternative prayer, and prayer 4, those don't breach the separation of powers because those engage the court's classic power under Section 172 to invalidate and declare unconstitutional. Insofar as prayer 5.1 is concerned, I could accept that there's a separation of powers concern there because of substitution, but our argument in response to that is that's also a classic doctrine that has been developed by the court to substitute for decisions in certain circumstances, which we say we meet. But if we were to talk about 5.2, for example, I would respectfully submit that that doesn't breach the separation of powers, because in the alternative, it would order a referral to the National Assembly to consider de novo, which the National Assembly would then do. And that also is not breaching separation of powers, because that kind of invalidation and reconsideration happens in constitutional litigation all the time.
Are you not, I'm sorry to interrupt
Sorry,
you.
Justice Chiefly.
Are you not asking us to say that the National Assembly should not have voted not to accept the panel report?
No, I don't think we see our case quite so broadly, because that would be an interesting debate about the separation of powers. The reason we impugn the National Assembly's decision here is because we say, insofar as the only reason that exists, it's this division of sufficient information and prima facie evidence, which I've addressed already. And because in our construction of the case, that's not a cogent reason, that's not a good reason, it results in an unlawful outcome, and that's why the court can step in. It's not a generic attack to say that whenever the National Assembly votes not to impeach, that's automatically unlawful. It's asking the court specifically to interrogate the reasons that were relied upon by the National Assembly in reaching that conclusion. And we say if that reason is unlawful, then this court can intervene. So with all due respect, I don't think we don't submit our case quite so broadly as the way in which it's being posited to me.
Thank you. CJ?
Thank you. Do you need to take a note?
I have no idea what it is, so I'm going to try and listen to you, Justice Majid, and then cast my eye downwards.
You can have a look at it first.
Thank you. I'm most indebted. Yes, I'm indebted, actually. What I would say, Justice Chiefly, going back to the debate that we had, apologies, Justice Majid, is that obviously we can accept that the substitution relief per se might create a separation of powers anxiety, but that if the alternative relief was granted, which is to specify or enumerate factors that have to be taken into consideration when that decision is reached by the National Assembly, that would be sufficient for us, because that in some way goes towards fettering and limiting a potentially unfettered discretion, which has the capacity of introducing political interference into the debate.
Thank you. I have a number of problems with the applicant's case. Some of the ground has been covered, but there are more, I regret to say. And you know, in Greek mythology, there's the Hydra with the multiple heads.
Yes.
And the myth is that once you chop off a head, it regrows two others.
Yes.
I hope it doesn't happen in this case, but let's start with, at the beginning, with
I
delay.
suppose two heads are better than none, Justice Majid. Or six in the case of my team.
Unless you're the one trying to chop them off like Hercules would.
Yes, no, absolutely.
But let's start at the beginning about the delay in this case.
Yes.
Now, as I understand your case, and please correct me if I'm wrong, your case is this. You say this debate about declaratory relief and review is just kicking up dust. You say it doesn't matter because in declaratory relief, you can claim more, or you could claim the same relief as in a review, and you're not bound to a decision. That's your case.
Yes.
So what you are saying is, I think if I read between the lines, that if it's a review, then delay comes glaringly to the fore. It would be a legality review, not so.
Yes, but it would hit more as to remedy, not as to the declaration. So it would hit more as to the 1721B inquiry, not the 1721A, because there's no doctrine of delay that will oust the court making a decision on the merits. but it may be that that is taken into consideration in the determination of the remedy. So yes, I accept that.
I must tell you, I don't follow that. I'm not going to try and understand it. I'm simply going to debate the matter on your
Yes.
on your case. Your case is declaratory relief.
Yes,
Now, you quoted Naptosa, and I looked in Naptosa for the silver bullet, and I couldn't find any. The silver bullet seems to be against you. Can we just go to the case, please?
yes,
Do you have it in front of you, Naptosa?
it's coming.
Now, unfortunately, you would know that this is a 2001 decision
Yes.
of Judge Conradi in the Western Cape.
Yes,
So it doesn't have paragraphs.
yes,
It's pre-paragraph judgment writing time.
yes. And the version I have in front of me doesn't even have the internal numbering, so
Yeah.
I apologize for that.
But let's go to, let's go to the paragraph that talks about the flexibility, which is the one you rely on.
Flexibility.
Yeah, you know where it is more or less. 'Cause-
May I, yes, and what if I can ask one of my juniors to just search that judgment electronically, because then that will bring us closer to.
Yeah, they can do a word search.
Yes,
Search and just
exactly.
look for flexible.
Yes, exactly.
But let me read what the problem is for you.
Yes,
Your argument is that based on Naptosa, declaratory relief can subsume review relief, so it doesn't matter. Well, it does. And that's also always how I understood the law, that declaratory relief entails a sense of exercise of discretion when it comes to remedy.
absolutely.
And their delay is one of the factors to be taken into
In the
account.
context of remedy, absolutely.
Because here the judge says, I consider that the substantial delay in bringing these proceedings, which was for declaratory, is another reason for exercising our discretion against the grant of a declaratory order. It says it is well-established law that undue delay may be taken into account in exercising a discretion as whether to grant an interdict or a mandamus, or to grant relief in review proceedings. And then he makes the point that you say it's a flexible remedy. But the point I'm making simply is this: can you and I agree that delay features even for your declaratory relief that you seek? Are you prepared to concede that?
For remedy, yes.
Yes.
Yes, and that has not been, we've not suggested otherwise. What we have contended, though, unlike in reviews, delay can speak to whether or not the review should be adjudicated in the first place, which is not a remedy question. We accept that the delay might be factored in the context of remedy, but it doesn't allow the court to, what we would say, sidestep the merits issue, which is the 1721A point.
Yeah. Well, I don't understand that answer, because if you say it's about remedy, doesn't it mean that you're not entitled to a remedy if you've delayed unreasonably? And let me immediately add why I'm saying this. It's not only delay. This seems to be a classical Van Wyk versus Unitas hospital case, because here you have a delay. And please, I'm putting the case as I see it,
Yes.
Mr. Prima. Please feel free to correct me where I go astray.
I'm indebted.
You have a 14-month delay
Yes.
on the papers,
Yes,
undisputed.
yes,
There is no explanation for the delay. And
yes.
third, most importantly, there's an argument, which I'd like to hear you on, because you didn't address it at all in your uninterrupted time, that once the 6th Parliament has dissolved,
Yes,
Section 49 and Rule 351 of the NA rule says, Parliament, 6th Parliament, your life is over, you're done, there's nothing left. So how can the 7th Parliament now be asked to consider work that died with the 6th Parliament? So mootness coupled with undue delay, and that is the problem that I have
Sure.
with the case, a la Unitas versus, Van Wyk versus Unitas Hospital.
May I take both of those questions in turn, Justice Majid? Let me start with the issue of delay. I fully accept what you say to me, but what we know about the discretion to be exercised in terms of the remedy is delay is but one factor. So if the court is going to consider the unreasonable delay, that's fine, but then the court also has to counterbalance that delay versus the public interest in the matter, the ongoing effect of the court's judgment and the relief that it will grant. And then the court must bring an evaluative assessment as to whether or not the complaint of delay in and of itself is of such severity that it outweighs all of those other factors. And we would submit that it doesn't in this case for the reasons that we've addressed in the papers, including public interest, including the fact this is about the president who has special obligations to uphold the rule of law and so on. So on the subject of delay, I accept what you say to me, subject to what I've just added about the factor and the evaluation that you have to make. That's the delay point. Insofar as the second point is concerned, and how I will try and answer the question is as follows. In the first instance, the court's declaration, if the court is with me, will invalidate everything that happened after the motion was tabled and restore, after the motion was tabled and after the panel gave its report, and restore that report. The status quo ex ante would be restored. That's the first point that I would make. So what the question then becomes, I suppose, is it competent for the seventh Parliament to adjudicate this report? Is it competent for the seventh Parliament to adjudicate this report which started in the sixth Parliament? And we would say, yes, it is, because when you restore the status quo ex ante, it's the National Assembly, not time-bound National Assembly in terms of the rule, but in terms of Rule 129, but the Assembly itself, which is then must then take the next step. So even though there's the issue of lapsing business, and we know that lapsing business is not absolute because there are instances where business is rolled over from one Parliament to the next Parliament, so it's not an absolute rule.
Well, that would be the revival of a bill, for example.
For example, yes.
But could you place it on the same footing as this matter? That's I looked at the revival of a bill. I understand that. But can you do this with a panel appointed under the previous Parliament that has done its work?
Yes, agreed. It's done its work.
And gone to Parliament.
Yes.
Parliament has decided. Now we've got a new Parliament, a new mandate from the electorate.
But Justice Majid, this is not something uncontroversial. It's something that happens all the time. For example, like we know when a court invalidates a tender, for example, and when it invalidates the tender and sends the tender decision back to the decision maker, oftentimes there's a change of personnel. It might be a new Director General, or it might be a new minister. The obligation does not attach to the individual occupant of the office. It attaches to the obligation to discharge the accountability function here to the Assembly itself. So we would say that in terms of what we are asking the court to do is nothing novel, and in fact only serves to emphasize the Assembly's obligation to discharge its accountability function. I know in the heads we refer to it as the ex-tunc versus ex-nunc debate. That's the way in which we see it, is the effect of the court's order would be ex-tunc in nature. And so the Assembly, however constituted and whenever constituted, would have to afresh then consider itself vis-a-vis the report. I understand the arguments that Justice Majid has posited against me. Those are as far as I can take it on that particular point.
I must just correct you. I'm not arguing the case. I'm
Yes.
trying to figure it out.
Positing the arguments, I should say.
Well, I want to tell you that we must compare apples with apples. It's one thing to talk of a tender which has been set aside and goes to another differently constituted adjudication committee. But here we're talking about the highest office in the land.
Correct.
Facing impeachment. And impeachment is not just, the end of a career. It means that you lose all your benefits.
Correct.
And it's a very serious matter. And that is why in this court, EFF2 said there need to be procedures in place.
Correct.
And they need to be complied with properly. And the National Assembly has the last say. That's the most important.
Correct.
Yeah. So I just want to get that out of the way. Now, I want to move on just to something else. And just to interpose and in brackets say that, I've listened to the debate between you and my brother Madlanga and my sister Tiki. And I read Makwakwa. Makwakwa are the people who fled from Lesotho after the coup d'etat. And then there was an application for extradition.
Yes.
The magistrate granted the extradition.
Yes.
And one of the things he had to consider was the prima facie grounds on which to grant the extradition.
Yes.
In that context, Judge Musi, with whom Judge van der Merwe concurred, said, well, prima facie evidence means there's sufficient evidence for the warrant, for the extradition to be done back to Lesotho for them to be charged. Now, I mean, no disrespect to those judges, But in the context of that case, it's an understandable thing to say, well, prima facie evidence means sufficient evidence. Here it's different. There are phases. The first phase we know is the member of the ATM comes to Parliament, says, here's a motion, and I contend there's prima facie evidence of these serious gross violations. Speaker looks at it. Speaker says, I agree with you, there's prima facie evidence. But now when it goes to the impeachment panel, this is a full-blown inquiry. It's headed by a former Chief Justice Noham, prominent senior counsel, well-respected retired judge. If I may say so, and I say mean no disrespect, it's a heavyweight panel.
Yes.
But the panel now it gets told, you must look for sufficient evidence. The threshold is higher, Mr. Premier, as I understand it, because it's no longer a question of whether we should set in motion the proceedings of an impeachment, of an inquiry into impeachment. It's now whether there is basis now for Parliament to decide on impeachment, which is a far more serious thing than to say to the police, investigate if there's enough evidence to arrest, and then the prosecutor must decide whether to prosecute. It's almost those two phases.
Yes.
So it's almost like the police.
Yes.
The complainant comes to the police station. The leader of the ATM comes to Parliament, lays a complaint. Police look at this and says, well, there's prima facie evidence, there's enough here to arrest. But when the prosecutor must decide whether to prosecute, it is prima facie, but it is a different threshold. So isn't there two different thresholds? And that is why the legislature in its rules calculatedly use these two different terms, prima facie and sufficient evidence. I can't understand how it means the same thing.
So may I just pick up on the example that Justice Majid uses? That's exactly correct. And that's why we say that the way in which Parliament voted down the report ultimately is premature and constitutes a preemptive strike, because it didn't consider the correct question in front of the panel, which was about the existence of this prima facie evidence. So we agree on a proper interplay between what the Speaker does, what the panel does, what the committee does, and what the National Assembly ultimately does. The analogy of a police complaint prosecutor is exactly right. That's what it's concerned with. Is there a case to answer? So insofar as the analogy is concerned, I adopt it because, with all due respect, we submit it makes our case. On the specifics, though, of what the panel had to consider, may I give a reference, if I could? I'm looking at Volume 1, page 34 of the founding affidavit, paragraph 109.2.5. The panel wasn't blind to this issue. And what the panel said, and I'll read it out if it's of assistance to the court, it says, in the context of the scheme for the removal of the president from office, we construe the phrase whether sufficient evidence exists to mean whether, based on the information received, the president has a case to answer. Put differently, we construe the phrase to require the panel to determine whether there is a prima facie case against the president. So on the panel's own wording, it says we have cognition of what sufficient evidence constitutes. We interpret that to be no different to the prima facie standard, which is the Magwakwa reasons that we had articulated earlier. And it goes on to say, it is not the function of the panel to inquire into whether the president is guilty of a serious violation of the constitution or the law or serious misconduct. That is the function of the committee, which is empowered to investigate the matter fully, including summoning persons to give evidence before it or to produce documents and hold public hearings. So as against Justice Majid's understanding of sufficient information or sufficient evidence, there must be something more to answer in respect of the case. The panel on the facts ticked that box for themselves and reached the conclusions that they did. And then what happens in front of the National Assembly is that is latched onto, with all due respect, by Minister Lamola. And the attempt to split out sufficient evidence and prima facie information arises, but which is no distinction at all, not only in the panel's words, but because of the Magwakwa reasons. So that's how we see it as having played out on the facts of the case.
I want to leave that topic there because that kind of language, case to answer, is typical of a civil trial. That if you have prima facie evidence adduced by a plaintiff, and you leave that unanswered as a defendant,
Becomes-
you may find problems on the preponderance.
Correct.
Same with an accused.
Yes.
If he or she leaves that evidence of the state unanswered, may get past 174,
Yes.
but may get convicted. But let's leave that there. I want to go to another.
Justice
part of
Majid,
the-
may I say
Yes.
that in terms of what you've just said to me, I agree with you. And where the testing of that evidence happens is in front of the committee. That's the way in which the rule envisages it to happen. So in our construction of the case, the panel draws the charge sheet, and then it goes to the committee where the competence or merits or otherwise of the underlying charges drawn by the panel is tested in front of the committee. And that's the point at which the president who is being investigated has their full fair trial rights available to them to mount whatever defense they want to mount. Thank you.
There's an argument of prematurity. What has happened with this new motion before the 7th Parliament now, which was brought on the
It died.
7th of July 2024?
It died. On the 24th of, we've raised this in chambers with the Chief Justice. There was a letter that was sent by the Speaker to the erstwhile MP, who was our client's MP at the time, to say that your motion, the second motion, did not tick the box of the 129A requirement, and therefore your motion is not compliant and won't be processed further.
It means then that you were, in layperson's parlance, you were chucked out on a technicality. You could conceivably bring that application back in proper form.
Yeah.
Yeah.
I could, but that doesn't, and taking that point to what I say it's logical conclusion, we would respectfully submit that the second motion stands on its own footing and engages something different. Just because there was an unlawful, let me put it this way, again in layman's terms, if I may. Let's just assume for the moment that the reasons for the National Assembly's outcome when it voted down the report was unlawful. And then the second motion came about and somehow, through a miracle, it was accepted and it was ultimately approved and the president was impeached. That subsequent impeachment may factually lead to an impeachment, but legally it has very little to do with the unlawfulness or otherwise of the first impeachment motion and the reasons it would have been voted down. So to the extent that there's and this is spoken to about prematurity, ripeness, mootness, all those technical defenses that respondents love raising when they get the chance to. Not sure what to make of that with all due respect, because apart from the fact that that second motion died, that first motion and its outcome is its own inquiry as to lawfulness and doesn't get altered by something that comes subsequently.
Can I just ask you a last question then on remedy? Let's say that this court is with you on alternative relief and remit the matter.
Yes.
What does that remittal mean? Does it mean that Parliament must now work with this report of the independent panel of Chief Justice Ngcobo? A, could you just maybe answer that one because there's a B coming?
Yes. May I just get the supplementary authority bundle again so that I can look at the actual rule? So if I understand Justice Majid's question correctly, it's assuming you're with us, you invalidate the decision, what happens to the report? We would say the report then goes back to the Assembly for the determination, the consideration of the report. 635. So that's the stage at which we would, no, I apologize, I'm inadvertently misleading the court. It's 129I at 633. The other one that I gave you the reference to was the committee outcome.
All right. That's your answer?
Yes, so it's 129I.
What happens then with the vote of the 6th Parliament? Those votes, what happened to them? We just strike a pen through them?
Yes.
Or press delete on the computer?
I beg your pardon?
We press delete on the computer for
Yes.
that vote. It seems to me quite drastic for a court to do.
It's what the Constitution enables you to do when you are confronted with unlawfulness, even if it emanates from another organ of state.
I have no further questions, just to say that the good news is in the end, Hercules does slay the Hydra.
Rather Hercules than Sisyphus, I'm afraid, but be that as it may.
Mr. Premier, can I
Justice Turan.
just touch on jurisdiction, please? The applicant relies on exclusive jurisdiction. Is that right? Yes.
Yes, Justice Turan.
And in the second prayer of your notice of motion, you ask the applicant ask for an order that this court declare that the panel's report was irrational.
Yes.
Does irrationality come into play with in an exclusive jurisdiction application matter? Is that not trying to bring a review in through the back door?
Only if one presupposes that irrationality cannot be vindicated through a declaration of unlawfulness, and that irrationality as a species of unlawfulness is unique to judicial review.
Is there any precedent of this court for that, for what you're asking this court to do?
Hopefully this judgment, Justice Turan.
Is there any, by precedent, I mean, is there anything that comes before this case
No.
that this court can look to for guidance where that has been done?
You have the cases that we've relied on in our construction of our declaratory relief being competent, starting with rail action.
My question, Mr. Premier, is there any precedent for what you're asking this court to do in this matter?
In terms of that prayer too? Yes. Not necessarily framed as a declarator application, but having consideration to rationality as a standard. The DA versus the President, the old 2013 Simelane case, is an instance where rationality was founded to invalidate the appointment of the then NDPP, Mr. Menzi Simelane. But I say that subject to the caveat that I'm not certain that that was crafted as a declarator. I accept it might have been crafted as a review. And it was an exclusive jurisdiction. I accept that too.
Now, in this matter, the applicant does not plead direct access in the notice of motion.
Sorry, Justice Turan.
The applicant does not plead direct access in the notice of motion.
Correct.
It's not dealt with in the founding affidavit.
Correct.
And it pleads this for the first time in the consolidated replying affidavit,
Yes.
which we find at volume 6, page 566, paragraph 21.
Yes.
And if you look at paragraph 22 of that replying affidavit,
Sorry, Justice Turan, did you say P566?
page 566.
I'm with you.
Yes. It starts, the pleading in respect of direct access starts at paragraph 21. If we look at paragraph 22, this is what the applicant says. In line with the SCA authority in Fisher, this court is permitted to find that the EFF's case warrants direct access, even if it is not specifically pleaded for if the facts that underpin such finding are pleading. Now, how does Fisher help the first applicant in this matter?
Remember what's happening in this replying affidavit is we're shadow boxing, in effect, a case that's made against us to say that this is a case for direct access. So the starting point is to say, no, this is not a case for direct access. This is a case for exclusive jurisdiction. However, to the extent that direct access may be an issue on the pleadings as an alternative to exclusive jurisdiction, the reference to Fisher and Ramatlele is to say that the scope of the dispute is obviously defined by the pleadings. And what we know from this court's judgment, for example, in the McBride decision of 2016 at footnote 25, relying on the old Mpatlele decision against the Electoral Commission, is that this court takes the attitude that it can raise any legal issue if the facta probanda are there on the pleadings. And so all the purpose of paragraph 22 is to say is we don't adopt direct access, but if we're made to say or engage with direct access, we can nonetheless come home on direct access because the facts to justify an order of direct access are pleaded.
If as you say, you don't come home on direct access, can this court consider the constitutionality challenge against the rules? Because that is not an exclusive jurisdiction
Yes,
matter.
well, the way in which this case is constructed is that on our case, it would be,
Please answer my question, Mr. Prima. If the applicants do not, as you say, come home on direct access, can this court consider the constitutionality challenge?
on the
against
rule
rule
129.
against-
I would say it could, but the hoops that the court would have to jump to get there are not.
No, on what basis could it? If we don't have direct access in this matter, or if the applicant doesn't establish direct access, how do we get to the
Yeah, it's on the same
constitutionality?
basis that I've answered.
How do we get to the constitutionality challenge?
It's on the same basis that I've answered previously. It's about the reference to the McBride and the Mpatlele judgment that the factor probanda are present to enable the court to give that order if it chooses. But I think the difficulty with respect, Justice Theron, is I'm now engaging a case on direct access, which was never ours to start with. And I think the difficulty that arises from the replying affidavit is we're responding to a case on direct access that was imposed on us from the respondents rather than engaging exclusive jurisdiction on terms.
So the applicant is not relying on direct access?
Yes, we've repeatedly said that.
Might be problematic for the
Sorry, Justice Theron, I didn't hear you.
Might be problematic for the applicant.
No, I
We
accept that.
leave it there.
If we're down on exclusive jurisdiction and then if I've nailed our colors to the mast in the way that I have, then direct access ipso facto becomes a problem. I don't run away from that.
Is the applicant's case that the National Assembly has failed to fulfill a constitutional obligation?
Yes,
And what is the obligation that they
to hold
have-
the president
that they
accountable.
have failed? And are we talking now about the 7th administration?
No, we're talking about
Right.
the vote down of the report that happened during the 6th, which has continuing legal effect, which is why we're in front of the court today.
In EFF 2,
Yes,
this court had to decide whether the National Assembly.
I'm sorry, Justice, I'm getting the authority passed behind me.
Yes. Yes, in EFF 2, this court had to decide whether the National Assembly had failed to fulfill some of its constitutional obligations, but the question there rested on the parliamentary mechanisms for holding
Yes.
the president accountable.
Yes,
Following that decision, the National Assembly has in fact enacted mechanisms.
yes,
So why do you say that it has still failed
because the sufficient.
when it has responded to what the court said in EFF 2?
Because it's the sufficiency of the mechanism adopted. That's the earlier reference I made to Glenister. It's the interplay between what is seen as the first judgment, which sets out the principle, and then the second judgment in Glenister, which is what the amendment was, and it was evaluated as against the principle. We say that the same logic applies here in respect of EFF 2. EFF 2 enumerated the principle, and this case now asks the court to test the mechanism chosen against those principles to determine if they're sufficient.
Please, can you repeat for me? Why do you say they're not sufficient?
Those are three overarching reasons. One is that the ability of the National Assembly to exercise a wide discretion at the point of the panel producing the report opens the door to political abuse. And so that existence of that wide discretion, where it's either the National Assembly has a role to play, or if it does have a role to play and it's not subject to factors, perpetuates the concern that was espoused in EFF 2. That's point number one.
Before you continue,
Sorry, Justice.
why is the wide discretion problematic?
Sorry, Justice Theron, I'm just making a note. The wide discretion is problematic exactly on the facts as we would say arise in this case. Because remember, even though when Minister Lamola was giving his address in Parliament, it was seen to be linked to a narrow evidential issue, what the affidavits reveal is that there were all sorts of political considerations and decision-making that was happening in parallel. And so in the absence of in the absence of the National Assembly not playing a role when the panel produces its report, or in the absence of factors to be considered for the purpose of that decision, to fetter its discretion, that's where the potential for abuse arises. And that's where we say the structure of the rule needs to be tested for its sufficiency.
And that's where the potential for breach of separation of powers comes into play, as my sister Justice Chikwi was debating with you. Exactly there.
Yes, and I repeat the answer then given to Justice Chikwi in that regard, that at the broadest level, the separation of powers is not as much of a concern for us in the way in which we've constructed the case, and that the two alternatives that have been sought in this court are recognized alternatives that are used as remedies in this court in public law disputes all the time. So we would suggest that the separation of powers concern is not as acute as that.
Yes, the question of delay has been dealt with by Justice Majid, and I won't delve into it, but it does concern me that there is no explanation for the delay.
Yes.
What is the first applicant saying as to how it regards this court when it comes here 14 months late that does not give this court an explanation for the delay? I think it's just too glib to say, well, there are other factors that the court can consider in the interests of justice. Why is there no explanation for the delay?
Maybe it emanates from incorrect legal advice that the delay doesn't have to be addressed because of the declaratory order as chosen. But to the extent that there's a criticism that delay is inadequately addressed in the affidavits, that criticism is perhaps well-founded. I don't think Justice Turan is inviting me to now give that explanation.
I'm definitely not.
Exactly.
I'm voicing the concern that the court has about that.
And I hear the concern.
And I'm giving you the opportunity to answer how we can address that concern, not giving you the opportunity to give any evidence, Mr. Premier.
No, that's entirely right. And it would be inappropriate if the invitation was extended. The point is that the court has, in other circumstances, and I will address this more fully in reply, and I'll make a note to do so, has dealt with other cases where there have been substantial delays. And but
now it seems that the court is creating problems for itself where it attempts to assist litigants. And perhaps the court should not be doing that. So litigants should know when there is a delay, there's a duty upon them to provide an explanation to the court.
Yes. Now, I hear the criticism and I hear the concern, and I quite frankly agree. But stare decisis is as stare decisis does. And if the court has exercised its discretion in the interest of justice in other matters where delays may have been insufficiently explained, that's the sum total of the explanation, I guess.
The applicant filed a consolidated replying affidavit in this matter. And in that affidavit, it raised certain new issues, one of which I had covered with you.
Yes.
There was a further opportunity to deal with the delay. And this is after the respondents in their opposing papers had already criticized the applicant for not providing a reason for the delay. So despite that, despite being made aware of the fact that there was no explanation, the applicant still did not at that stage consider it necessary to tender an explanation.
And I must accept the criticism. One's also caught between a rock and a hard place in that instance, because then if one strays into an explanation on a so-called new issue not addressed in the founding affidavit, the immediate response is you're then making out a case and reply. So in an imperfect circumstance where delay is raised as a respondent as an issue that is relevant for the matter at hand, it is somewhat difficult for an applicant who finds themselves in that situation to then deal fully with an explanation on delay, particularly where, and again, this is subject to correction by this court, obviously, it chooses a modality of relief that delay does not play as much a part as it would if it were a review, for example. But I hear what Justice Turon says, and the issue is as it is on the papers.
My last concern, which has been touched upon, is that of doctrine of breaching the doctrine of separation of powers. Now, once again, is there any precedent that you can point me to from this court where substitution has been ordered in a case like this? Where substitution has been ordered by this court, where there's a danger of breaching separation of powers?
No. Other than on similar facts to this case, I would say no. Obviously, the separation of powers issue and substitution.
On any facts, doesn't have to be similar to this case, but where there's a danger of breaching separation of powers, has this court ever ordered substitution?
And are we limiting the engagement only to issues of exclusive jurisdiction, or are we saying generally? Because there is a case, and Trencon is the leading authority on the substitution point, where the separation of powers was foreshadowed by the court. And the court's answer in Trencon is that separation of powers is actually not really a concern, because the court ultimately is the one that enforces the Constitution. And if the repository of the public power exercises that power incorrectly or achieves an unlawful outcome, then the court, if it is well placed enough to make that same decision, can, despite the separation of powers concerns, because all of the exercise of public power stems from the Constitution, of which the court is the upper guardian. So
I'm only going to remind you of the opening sentence of the minority judgment.
the minority judgment, yes, Justice Turon.
Are you relying on the minority judgment?
No, no,
Yes. I'm going to remind you only of the opening sentence of the minority judgment in I think it was, yeah. It was the secret ballot.
My
Yes,
vote
UDM,
counts.
the UDM matter.
Oh, UDM, yes.
Yes, where the minority judgment started with, this is a classical example of judicial overreach. So separation of powers is always a concern, Mr. Prima.
Yes.
Yes, but
Well,
I leave it at that.
Justice
And we shouldn't downplay it.
No, Justice Turon, may I say, as a conservative constitutional lawyer, I completely agree with you and endorse your sentiment. But the reality is that the court's precedents are what they are. And unless any respondent in this matter or this court itself is willing to impugn its prior decision, stare decisis applies. And Justice Brunt, if I'm not mistaken, when he was an acting judge of this court in Camps Bay, made that abundantly clear at para 28. Precedent not only applies vertically, it applies in respect of the court and its prior decisions. So in as much as the separation of powers concerns are what they are, the majorities in these judgments have broken the other way, and therefore they're justiciable principles which a litigant can rely on. But I share your concern.
I'm not going to engage in a debate, Mr. Prima, about whether this court has in cases breached separation of powers or has gone too far. I'm not going to engage that debate. I've raised the concerns and I leave the matter there. Thank you, Mr. Prima.
Thank you, Justice Turon. May I, Justice Turon, before I face questions from someone else, there was the question that was asked specifically about examples in this case, and I see lots of a flurry of activity from my teammates suggesting that the answer is EFF 2 at para 46. No, I think I have. No, I apologize. It's not EFF2. The issue of substitution was Trencon at para 46. That's the reference I wanted to give. My apologies.
Yes, thank you.
Mr. Premier,
Justice Collop.
you relied on DA versus SABC I just want to get some clarity whether you seek to invoke it with regard to what a future scenario might look like, rather than what the present scenario is. Let me be specific. In DA versus SABC, the court concluded that the report of the public protector was binding
Yes,
unless it was reviewed and set aside.
yes,
That's not the case here when this
Correct.
report served before Parliament, correct?
correct.
So whether we ever reach that stage is debatable, because the independent panel is quite different from a Chapter 9 institution. Chapter 9 institution gathers evidence, tests the evidence,
Yes.
subjects it to cross-examination, etc.
Yes,
And therefore, for a court to conclude that that report is binding is underpinned by a number of jurisdictional facts which doesn't exist
absolutely,
yet.
absolutely.
So having set that aside, would you then accept that if the report was not binding on Parliament, Parliament was at liberty to consider the report and to consider it critically,
Yes, but
but not to have the wide discretion that you say it did?
we're at Eden.
Fine. Now, even if it had to use a narrower discretion, it's calling into question of whether the panel misconceived its role in setting the standard at that of a prima facie case. And we've had the long debate with my other colleagues, would not appear to be unreasonable. Certainly it was a valid point to raise and would fall within its narrow discretion.
Justice Colopin, as subject to if I've misunderstood your question, the issue for us is not the inclusion of factors is not applicable as against the panel. The inclusion of the factors is as against the narrowing of that wide discretion that otherwise vests in the National Assembly. And the reason that we say that those factors, which is the alternative to the automatic referral issue we've debated, need to be present is because, like the court identified in EFF2, and it decided as similarly in Oriane Ambrosini and Mazibuko before that, is that these rules, in as much as they are presented as neutral.
Sorry to interrupt. you
Sorry,
there.
Justice Colopin.
You're postulating what the ideal situation should be. I'm really wanting to get to what was before the National Assembly and whether they were, absent any amendment to the rules, entitled to critique the report, certainly on the basis that the panel got it wrong on the law with regard to the test.
Yes. But
If that is so, then surely that can't survive a rationality challenge. And secondly, surely in that regard, Parliament would have discharged its obligation to hold the President accountable. Because to hold the President accountable doesn't automatically mean that you have to establish an impeachment committee.
I fully accept
It would
that
be
last.
entitled to say, well, we've
Yes.
got this report that requires a level of sufficiency.
Yes.
The panel misconstrued its role by lowering that standard to one of a prima facie
Yes.
standard, and on that basis, we're entitled not to adopt this report.
But that only survives constitutional scrutiny if the reason relied upon by the National Assembly to vote down the report on that basis is itself a lawful reason. And if it's a mistake as to fact or a mistake as to law in terms of what the different thresholds means from Hurt and Carter and ATM versus the Speaker, which are recent SCA judgments, if that is material to the outcome because of what the court previously said in Allpay, then that vitiates the decision with unlawfulness. So I wouldn't be willing to say it survives a rationality challenge because that invites the question about whether or not the reason relied upon was an actual fact a good reason.
Well, it may well be.
Yes.
On the basis.
Yes. But I hope I've answered that rationality point, Justice.
Oh, you've responded. Thank you. And just finally, there's a principle, and I can't remember the case, where the lawmaker uses the same term in legislation, then it must be given the same consistent meaning wherever it appears.
Yes.
And the corollary of that must be that when the lawmaker uses different language, then it must be intended to give it a different meaning. And I simply ask this question in the context that it was open to the rule makers to use prima facie consistently. Yes. If it intended that to apply in respect of a motion and intended it to apply in respect
yes.
of a report. is it incumbent upon us to go beyond that, to say, well, it must have meant prima facie, and therefore it doesn't really matter what the panel's interpretation of it was. We have to give effect to what does the rule mean, and did the panel understand the rule correctly?
Yes.
If it got it wrong, it got it wrong,
Yes.
irrespective of how eminent the panel may be.
Yes, and as eminent as they may be. No. So 3 very brief responses, if I may, Justice Colleton. In the first instance, we would say that that distinction is no distinction at all. You've heard me on that already. So in the panel applying its mind and equating those 2 things, there's nothing wrong with that because those are all within the same species of prima facie. That's the first point. The second point is that...
I just want to intervene by saying that
Yes.
if that was its case, then there would have been no need for it to place anything before the president, not so. Because prima facie is what is presented to it by those who complain.
Yes.
By making the information available to the president and the supplementary information and giving the president an opportunity to respond, surely that took it to a different level than the original motion.
Yes.
And therefore, sufficiency under those circumstances must automatically lend itself to a different and a higher standard.
Yes, which we say the panel met here. Because
Whether it met it factually is another matter. But it characterized
Yes.
standard. You could argue that if you look at the report in its entirety, it may have met a standard beyond sufficiency.
Yes.
But that's not the question
Yes.
we must answer. The question we must answer is the panel decided that the standard it had to meet was one of a prima facie
Yes.
case.
And you've heard me on why it's doing so is competent. So that was my first set of answers. My second set of answers is that the nomenclature difference need not necessarily arise in a different standard if applying the rules of interpretation results in a sensible outcome. Obviously, the debate is whether the sensible outcome is the higher standard or the lower one, vis-a-vis the panel report and the motion, but we say that that's the consistency that is evident throughout the rule. And the last response is that the panel here doesn't do something akin to what the SCA did in the Moyo and Sonti matter, where in seeking to save, I think it was the Intimidation Act, if I'm not mistaken, or maybe it was the Incitement Act, I speak subject to correction. What the SCA did is it read in a whole number of qualifiers in order to rescue the provision overall in terms of its constitutionality. What the panel did, to the extent that it applied its mind and said that sufficient and prima facie is the same, is not in that territory at all. So to the extent that there has been a difference in the nomenclature and it's been interpreted in a particular way by the panel, then that's fine in our construction because it's not actually a reviewable error that they've committed. They've adopted a standard of evidence which is defensible in law. Thank you.
Mr. Premier? I'm here.
Sorry, Justice Matopa. May I just give one last reference to Justice Colleton, if you don't mind? And on the facts, Justice Colleton, the reference I would give you is in page 90, volume 1, paragraph 76, from line 22 onward. And the panel in its own words says the following: it is a momentous act justified only when sufficient evidence exists. Remember, sufficient evidence is what is used in the rule. Sufficient evidence exists to show the president has a case to answer for his conduct. The panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. So assuming, Justice Colleton, that there is the distinction between prima facie and sufficient evidence, what the panel is doing here is it says that that's that higher threshold that we're meeting all the time. We're just calling it prima facie evidence.
Well, I think this creates further difficulty for me because what it says is the panel therefore functions as a filter to ensure that only a motion which establishes prima facie president has a case to is considered. But that's precisely what the Speaker has done, Natsa. The Speaker has satisfied herself that the motion satisfies the requirement of prima facie evidence, and therefore the Speaker has no discretion. The Speaker is obliged to appoint the panel
Yes, but the speaker's assessment of that is measured as against the 129A provision, whereas the panel considering that sufficient evidence threshold is as against 129G. And and again, I think it takes me back to the debate I was having with Justice Shikri earlier about the duplication, then what's the purpose of the panel? It's that the speaker doesn't play as intensive a role as the panel does. And so even though the speaker considers whether or not there's the prima facie evidence, that's only in terms of the tick box exercise for the competency of the motion, not the underlying charges. That's the role to be played by the panel. So when the panel talks about the motion, it's a motion that passes the speaker's hurdle, but on its terms as a charge sheet, if I can call it that, is competent to make the prima facie threshold.
Okay. I think we've
Yes,
probably been, yeah, thank you.
Thank you, Justice Colopin. Justice Matoko.
Just to follow up on that last part,
Yes.
if you look at volume 2,
Yes.
at page 143,
I'm with you.
there's been the report of the panel. This is where they say, viewed as a whole, the information presented to the panel, it's not them, prima facie
Yeah.
establishes that there was a deliberate intention. So the word prima facie has been used throughout by the panel.
It has. But the earlier portion that I read to Justice Colopin is an earlier paragraph where they're explaining what they understand by that.
Now let's look at that.
Yes.
You and I as lawyers. If the panel uses the word prima facie and sufficient evidence interchangeably as if these were synonyms, that is wrong. Forget about what Makwakwa said. My brother Majid has taken you through
Yes.
what Makwakwa said.
Yes.
That is wrong. And if a wrong test has been applied, it invariably would lead to a wrong conclusion.
Yes.
So isn't the case here that the report has to be impugned because it is based on a wrong test? The panel conflated the two tests
Yeah.
as if it's one and the same thing.
Yeah.
You and I know that it is not. We have to search through the report to find the word sufficient evidence to save it. This is a report by 3 eminent lawyers. Do you have an answer to that?
I'm not going to repeat my submissions that you've heard already on the issue of the threshold. But I think in the way you've constructed it to me, I accept what you say, Justice Matoko,
This
subject
court,
to that caveat.
just to remind you, this court in State versus Tuta, a judgment written by Acting Judge Unterholter, in which my brother Colopin also wrote a minority judgment. There was a misunderstanding or a misapplication of the test. And as a result of that incorrect application of the test by the trial court, it came to this court, the conviction and sentence was set aside.
Yes.
And if that's the case, then Tuta is against you, number one. 2, you know the tests in criminal law, it's proof beyond reasonable doubt. If a court convicts on a balance of probabilities, the test has been incorrectly applied. The examples are myriad. So even in this case, the fundamental or the fundament of the report by the panel is just wrong. It must be called for what it is.
Sorry, Justice Matoko.
Do you agree or you don't?
I disagree on the basis of what I read out earlier, because the risk inherent in what Justice Matopo is positing to me is what I would respectfully say is a form of a substance error potentially. Because what the panel says is the panel in its mind, and based on that earlier paragraph that I read out, which if I can get it, it will be helpful. But based on the earlier paragraph that I read out, it's not that they were thinking about two separate things. Even though they might have used prima facie prima facie evidence subsequently in the report, what they continuously tell you insofar as how they understood the meaning of that is that's related directly to the evidence of justified only when sufficient evidence exists.
But look at the conclusion that I've drawn your attention to when I first started my
Yes.
question. It says viewed as a whole. In other words, in conclusion, that's what they're saying. They've nailed their colors to the mast.
But
That's what they're saying.
I-
Forget about how they took the journey or they undertook the journey.
Well, I think that puts me in a difficult bind because it asks me only to consider what they say in the conclusion, despite what they give earlier, which adds color to that conclusion, which is the paragraph that I just read out. I mean, if I have to ignore that, then the way in which Justice Matopo presents it to me is unanswerable. But I would say that that is at the risk of the form over substance issue because of what they say here at para 76.
Are you prepared?
75?
Are you
No, it's
prepared?
76.
Are you prepared to accept that at the initiation of the complaint, there has to be a prima facie evidence?
Are you talking about, Justice Matopo, when it goes to the speaker?
Just at the beginning, initiation.
I accept that.
And are you prepared to accept that when the panel conclusion has to be based on sufficient evidence or both, or it doesn't matter?
Well, based on what I read out, it doesn't matter because they've equated it to the same thing. Substantively, even though they're calling it prima facie evidence, that the test and the threshold which they themselves are seeking to answer is as set out in that paragraph, which is sufficient evidence exists for the president to answer a case.
Okay, let me wrap up and move on to something else different briefly. What I don't understand is why the applicant did not directly and frontally challenge the rules. One, the relief that has been sought, the resolution that was taken in December, and everything that goes with it. The ship has left, has sailed out. If the EFF had challenged the rules and asked for an amendment before the National Assembly, wouldn't that have been a prudent move to do? Short of lumping the whole thing with what it has done now?
No,
I'm
because
bringing into question the issue of delay, mootness,
I hear you.
prematurity.
No, I hear you. That would only be competent vis-a-vis the attack on the rule, but then it would still leave the substantive outcome of the National Assembly's decision and what is to be made with that. So the EFF is in the court because it says that's the exclusive jurisdiction issue. And because the decision that was made and which is being impugned is in terms of Rule 129, that invites it and this court then to consider the competency of the rule as it is now constitutionally challenged in front of this court. The EFF's case is not only about the rule. If it was only about the rule, then I think Justice Matopo's observation is correct. Maybe it should have gone in the High Court and started there and attacked the rule or whatever else.
Yeah, but how good is the EFF's case in respect of the other prayers? I mean, let's look at it practically. What is it seeking to do?
It's seeking to
I
get,
mean, if it goes to the rules, it's something else. It might have a case to sustain. But all the other reliefs, I don't know. Hasn't it misconceived its position? Just think about it. Move away from the issues and look at the practicalities. And take a step backwards and look at the issues. What is it that the EFF seeks to achieve? The EFF seeks an amendment to the rules. Its complaint is not what happened, because the boat has sailed. Its complaint is the rules as it is now gives us a problem. That's where the problem is. No other problem. All of these things are just lumped out to create an atmosphere. Just, do you agree with me or you don't?
I disagree, and I disagree for the following reason.
Mr. Permit, would you mind giving us the reasons after the tea adjournment?
Of course.
come back at 11:30.
I wanted to move those too far, but that's not the thing. And the question arose as to whether in striking down the report, the panel properly took into account the question of bad faith. So it's not us saying that the President acted in bad faith, it's really a question of whether the panel properly interrogated bad faith. And what the panel did, if we understand it properly, is in the paragraphs that I read, I think it's particularly paragraph 63, the panel said, you can't look at bad faith on the basis of what the President says. So the President, he filed a letter, and he said, I wasn't acting in bad faith when I did what I did. He said that. And the criticism by the ANC and the President is, well, the President said he acted in good faith by doing what he did, and therefore the panel was wrong to find that he acted in bad faith. And what the panel, what the true import of the panel's report was this: you can't look at what the President says, you can't look at what General Rhoda said. You can look at all the facts and circumstances, and you draw an inference. And what they did was, they said, if you look at all the facts and circumstances, perhaps the reasoning, yeah, and the criticism that they didn't consider bad faith is a bad criticism, because they did consider this. And the way they dealt with it might not have been the way I would have dealt with it, court might have, but they dealt with it. Whereas the ANC and the President said they didn't do it. That was the hard-reaching evidence.
That is a finding that made.
So we had to.
So we have to ascertain the basis of that bad faith by the panel. What would be those facts, the elements of bad faith?
What the President did once the theft was brought to his attention, look at what did he do after the theft was brought to his attention, and what did he do before? What was he doing with the dollars in the couch in the first place? What's his explanation? And if one sees that globular picture, the panel says that globular picture points to bad faith. Globular picture, fact by fact by fact, like in circumstantial evidence. Why is the man guilty? Drip by drip by drip until there's a river. That river is why the man's guilty, not the President. That's how circumstantial evidence becomes evidence to convict a murderer, for example. And what the panel did, drip by drip by drip. Why didn't he report it to the proper authority?
But he reported to Rhoda, his special advisor.
Special protection unit. It's got nothing to do with crack or the prevention of corruption. It's a security police. And he goes to Namibia, Cape Town, and you look at those facts, drip by drip by drip. It's not one fact. You look at what did the President do, big picture. Why? And the question is, why were the dollars in the couch?
But he wouldn't know why the dollars were in the couch. It's an ex post facto application that was given why the dollars were in the couch. Whether it's right or wrong, whether it's preposterous, it's something else. He was just reporting why the dollars were in the couch. Everybody, you and me, would be astounded to say, why are you keeping the dollars in the couch? But they were there. And they were stolen there as allegedly as we were told.
Well, with respect, I agree with you, Justice Ngcobo, that I would be astounded. I am astounded. I think all of us can be astounded that $500,000 are found in a couch. And they need to be an explanation for why they were found in a couch, number one. He says, well, I didn't know about it, his advisor put it there, whatever the explanation might be. But then what does he do? He says to his security guy, go and report it. Well, he didn't say to the security guy, he didn't do that. He reported it to the security general. That's not appropriate. That demonstrates bad faith. But the whole picture, that's the answer. I can't do better than that. But how could, the question I suppose is this. In a case like this, what would the ATM, what would Mr. Zangulu have to produce by way of evidence to show bad faith? What he produced. And then he says, and then the president goes to the Limpopo ANC, says, not a problem, I'm a farmer. That's why the dollars are on the couch. That's a violation.
No, that's not what he said. No, that's not what. That's not what he said.
Well, that's the debate. What I'm trying to say is, what was he doing with the dollars on the couch other than business? And Justice Montropo, you put to me, well, there might be explanations for why the dollars were in there, and there might be. But certainly not consistent with
There is an extensive explanation given by one of the workers why the money was in the safe, and suddenly the safe is not safe and they put it in the couch. The person doesn't know about it. You and I can look at it and say, suspicious money. It's supposed to be safe in the safe. Take the keys with you. That's not what happened.
That's not true, but that's why you have an impeachment committee hearing. You and I think of it. That's what the public are there for. We want to know what happened. You have an impeachment committee hearing, by the Committee of Parliament, and at the end of that committee, there might be, the president might come out white as the, well, that's, I don't want to be racist, but he'd come out as clean as the driven snow. He'd come out clean. No. So, the point, that's the truth. He isn't clean at this time. And the panel, fine. He's not clean with bad faith. It's also, and you shouldn't second guess the panel. Why should Parliament second guess them? Drip by drip by drip. That's the best I can do. They can't punch a particular thing that he did which was bad faith. And the question, the real question, leave aside all of the corruption and money laundering. And I'll ask the question rhetorically. What's the president doing business? The Constitution says that when the person becomes a president or a member of cabinet, he must cease doing other business. That official's got cash in his couch. That's clearly a violation of the constitutional requirement that he doesn't do business.
But is this now your case for something else?
No, it's one of the 4 charges that my client put to the panel, or to put to the speaker, put it to the panel. No, they're all there. That's bad faith. There's no explanation for it. So that's why I said, my client put before the speaker 4 charges. I don't need to repeat that. All of those might involve ultimately a finding of serious misconduct of the constitutional law. But at a prima facie sufficiency of evidence that certainly meets the standard of evidence. And that is required might even be unconstitutional. That doesn't matter. I shouldn't go there. I don't want to go there. Bad faith was not ignored by the panel. It was dealt with in terms, and for Minister Lamolo to say it wasn't dealt with, or the ANC to say it wasn't dealt with, is factually wrong. That's all. I mean, the panel might have got it wrong. That's not the point. They dealt with it. Thank you, Chief Justice.
Thank you, Chief Justice. Issues. The first is we will endeavour to explain why the challenge to Rule 129I is ill-founded. And secondly, we will explain why in our submission the challenge to the National Assembly's 13 December 2022 resolution, which was taken in terms of 129I3, has been brought fatally late. Dealing first with then the challenge to the rule. I have to say I was somewhat taken aback by the submissions made by my learned friend, Mr. Katz, for the ATM on that topic today, for the following reason. The ATM applied to intervene as an applicant in the matter. The application was granted by this court on the 29th of August, and this court added that it was granted leave to file written submissions and to make oral submissions. It did file written submissions, and I've checked them again. There is no attack on the rule in those written submissions. The focus is on the resolution of 13 December 2022. My learned friend went further. He argued that some of the relief sought in the notice of motion, specifically paragraph 6.1, should be amended, and that in the absence of an application for amendment. And we heard all of this for the first time today. I act together with my team for the Speaker and for the National Assembly, whose rules are impugned in this matter. And with respect, we contend it is unfair that none of this was raised in the proper way in the written submissions in accordance with the directions of this, of the Chief Justice in this matter. And we will accordingly focus on the cases pleaded in the EFF's papers, to which the ATM joined. Now, they challenge Rule 129I on two grounds, as the court will know. They're advanced as alternatives, and each is coupled with a specific remedy. The first challenge, as we understand it, is that Rule 129I is inconsistent with two main provisions in the Constitution. The first is Section 55(2)A, and the second, Section 89(1) itself. And more specifically, as those sections were interpreted by the majority of this court in EFF2. And the reason, as we understand the challenge, is that it's unconstitutional. This is the first challenge, is because it allows the National Assembly to vote against referring an impeachment motion to the impeachment committee in circumstances where the independent panel has found that a prima facie case of impeachable conduct has been made out. And we see that summarized in paragraph 6.1 of the notice of motion. And if that first challenge is upheld, then the EFF, but on what my learned friend Mr. Katz said today, not the ATM, seeks an order directing, and this is paragraph 6.2, that the Speaker of the NA, the National Assembly, amend the rule in such a way that if the panel makes a prima facie finding, the presidential impeachment motion is automatically referred to the impeachment committee. May I just say that, of course, it's not open to the Speaker to amend the rules of the National Assembly. It is a matter for the National Assembly itself, but that is a relatively minor blemish in the case that we are facing today in the greater scheme of things. But as was put to my learned friends this morning, what is essentially being asked is that this court direct the Assembly to take the Assembly itself out of the equation until finally the impeachment committee is reported at the end of an impeachment trial before that committee. That is the remedy that's been sought. But it is, of course, dependent on the underlying proposition that it is unconstitutional for the rules to permit the Assembly to vote against the President's removal, the referral to the impeachment committee in circumstances where the panel has found that a prima facie case of impeachable conduct exists. So the two are inextricably linked, the reason for it and the remedy that are being sought. The second, which is the alternative challenge, second order challenge, is premised on the Assembly having a discretion. The first one, of course, is that there should be no discretion. They must simply be taken out entirely, and there must be this automatic referral. The second attacks the discretion. As we understand it, it is that the rule against vagueness, which is, of course, immanent in the constitutional principle of legality, is infringed because Rule 129I is impermissibly vague, and so the argument goes, it is open to abuse by the National Assembly. And the remedy which has been sought, if that second ground of challenge is upheld, again by the EFF, but not on my learned friend Mr. Katz's showing, the ATM, an order directing the Speaker, again, to amend the rule to include suitable guidelines structuring the exercise of the discretion. Now, before dealing with the merits of those two grounds, and I will deal with the merits and their remedies in one because they really, the one follows from the other. I wish to point to what we respectfully submit is a preliminary difficulty with the first challenge, the one which takes the National Assembly out of the equation. And it is that the challenge doesn't go far enough because it should have been coupled with a challenge to part of Rule 129P sub 2. More specifically, the part which provides that a recommendation by the panel isn't binding on the National Assembly. And indeed, there would have to be many other consequential amendments to a rule if the automatic passing of the motion to the impeachment committee were to be ordered. One sees, for instance, in 129J, which establishes the impeachment committee, the rule says it's established to consider motions in terms of a Section 989 inquiry, refer to it in terms of 129I3 above. But I suppose those problems could be dealt with under the general prayer for alternative relief that one finds, further and alternative relief. But we do point out, and this is that there would have to be certain further consequential orders made in order to practically give effect to that. Having cleared the decks with what is now sought in this preliminary niggle, I wish to now deal with what we contend are two fundamental difficulties with the first challenge, the no discretion or automatic transmissibility challenge. The first concerns the principle of separation of powers in the Constitution, and the second concerns the conferral on the National Assembly by Section 57(1)(a) of the Constitution of the authority to determine and control its internal arrangements, and specifically how that has been interpreted and applied by this court in judgments relating to the Assembly's obligations under related provisions, sections 42(3) and 55(2)(a) of the Constitution, and also obviously EFF2, section 89(1) of the Constitution. As the court will have appreciated, will know that both the ground of attack, this first ground of attack, and the remedy that the applicants are seeking will shift away from the Assembly to the panel, the power to decide whether a motion for impeachment of the President should be referred to the impeachment committee. And with the greatest of respect, we submit that if the court orders this shift, that will infringe the constitutional separation of powers of the judicial and legislative branches of the government. Because the result would then be this court, our highest judicial body, dictating to our highest legislative body that the latter must accept the opinion and the decision of outsiders to the NA, in other words, non-members of the NA, on whether the President has a case to answer, in other words, whether there should be an impeachment trial. And that then brings us to what this court, how this court has approached this difficult terrain in its earlier judgments. And we refer in this regard, firstly and in particular, to the approach of the majority of this court in EFF2. And we stress particularly paragraphs 129 to 131, 179, 180, 196, and 208 of that judgment, as well as obviously the orders that were made to be found in paragraph 222 of the report. And the approach of the majority can be summed up as follows. The National Assembly is the institution which bears the obligation to put in place and to implement mechanisms and processes to hold the President accountable in terms of Section 89(1) of the Constitution. And this is explained in response to, it's explained, by Justice Froneman in his separate concurrence in EFF2 in response to the Chief Justice Mogoeng's judicial overreach criticism of the majority judgment in that case. And if we refer particularly to paragraphs 283 and 284, in which Justice Froneman, who did concur with Justice Jafta in his judgment, added, according to the second, in other words, the majority judgment, Section 89 requires that before a resolution to remove the president is voted on, an investigation into the existence of the preconditions set out in that subsection must be carried out. The second judgment directs that the National Assembly to make rules for this procedure, and then later on, the Justice Froneman said, nowhere does the second judgment prescribe the content of the rules. And that is echoed by this court's approach in the first EFF matter in relation to sections 42 sub 3 and 55 2b of the Constitution. And there this court held that it's the Assembly and not the courts which must determine how best the Assembly should carry out its parliamentary oversight mandate in terms of those two provisions. And we refer in particular to paragraph 93 of the judgment. I won't read all of it. I'll just read a few sentences. It starts by saying, it falls outside the parameters of judicial authority to prescribe to the National Assembly how to scrutinize executive action, what mechanisms to establish, and which mandate to give it for the purposes of holding the executive accountable and fulfilling the oversight role. The mechanics of how to go about fulfilling these constitutional obligations is a discretionary matter, best left to the National Assembly. And towards the end, it is therefore not for this court to prescribe to Parliament what structures or measures to establish or employ respectively in order to fulfill responsibilities primarily entrusted to it. And the last judgment that we wish to, or part of that judgment that we wish to refer to in this connection has to do with the Assembly's duty when presented with important reports or reports of important institutions. Now that case, the so-called Nkanda judgment, dealt with a report by the public protector which reached certain findings in relation to the upgrades of the then president's home and held that there be certain remedial steps taken. And this court said in paragraph 87 of that judgment the following of the public protector's report. The National Assembly was indeed entitled to seek to satisfy itself about the correctness of the public protector's findings and remedial action before it could hold the president accountable in terms of its sections 42.3 and 55.2 obligations. These sections impose responsibilities so important that the National Assembly would be failing in its duty if it were to blindly or unquestioningly implement every important report that comes its way from any institution. Both sections 42.3 and 55.2 do not define the strictures within which the National Assembly is to operate in its endeavour to fulfil its obligations. It has been given the leeway to determine how best to carry out its constitutional mandate. And for all of those reasons, we submit that the first challenge and the relief based on it, the first challenge is with respect bad and the relief based on it should not be granted. Coming to the second challenge, which as will be recalled is that the rule, that's 129I, is impermissibly vague and hence the discretion it confers is open to abuse by the National Assembly. You will recall from our heads of argument that relying on the case of Van Rooyen, the judgment of this court in Van Rooyen at paragraph 37, we submit that the possibility of abuse has no bearing on the constitutionality of the rule. because should the power be abused, the remedy lies not in invalidating the rule, but in the remedies afforded by our law for abuses of public power. So with respect, we can put that to one side. The real question is whether well, perhaps I should just add this. It's only in circumstances, and they will be rare, where an empowering provision is so framed that it will invariably be abused. In other words, it enjoins the repository of the discretion to act in an abusive way, that the Van Rooyen principle won't apply. The real issue here, though, is this rule unconstitutionally vague. And the principle established by this court, one of the principles established by this court in the leading case of Darwood at paragraph 53, is that a rule will not be vague in circumstances where the factors relevant to the exercise of the discretion are clear. Now, if it's of course on its face, Rule 129I doesn't list those factors, but it is now trite that one needs to interpret any provision in a measure like this in its context and with regard to its purpose. The relevant context is provided by the preceding subsections. And the architecture of this rule is essentially this. Once a motion contains allegations which, if established on the evidence, will entail impeachable conduct on the part of the president, that's the screening function that the Speaker undertakes, the so-called Prima facie assessment. You look at the document on its face to see if it contains the allegations substantiating impeachment. It must go to the panel. And this is where particularly important to have regard to Rules 129G1B and 129(1)C5. Because what the panel has to do is to look into the information that it is provided with by the sponsor of the motion, by anyone else, any other members that the panel permits to provide information, as well as the President's response, and then to submit a report containing a recommendation whether sufficient evidence exists to show the President committed whatever the ground of impeachment is, a serious violation of the Constitution or the law, etc., or suffers from an inability to perform the functions of office. And it has to set out in its report the findings and reasons for the findings on which the recommendation is based. We see that from 129G1C5. And we know from Rule 129P, to which I've referred, that this is an advisory report. So the structure is that an independent panel must look into the information and it must produce a report with findings on those matters. And why is that? And the answer is so that the Assembly can decide, aided or assisted by that advice and the analysis of this panel, which have to comprise experts and our legal experts, whether sufficient evidence exists to put the President on trial, an impeachment trial before an impeachment committee. That's the context. And that ties to the purpose. The purpose is of this power conferred on the Assembly by 129R3 is to decide whether the matter must go to an impeachment inquiry or a trial, where the seriousness, where evidence will be heard, and the veracity and where relevant, the seriousness of the charges will be determined, and that committee will then, in turn, at the end of the trial, submit a report to the Assembly, which takes the final decision on whether to impeach or not. So that's the context, and we submit that when Rule 129R3 is read in context and with reference to its purpose, the factors relevant to the decision-making powers it confers are clear, and it boils down to this. the Assembly must consider and decide whether or not it agrees with the panel's recommendation that sufficient evidence exists or does not exist, as the case may be, to show that the President committed these serious violations of the Constitution or the law alleged in the motion for his removal, or committed the alleged serious misconduct, or suffers from the alleged inability to perform the functions of office, as the case may be. And we respectfully submit, in the light of that, that it cannot be concluded that Rule 129I3 is impermissibly vague. And for that reason, my clients ask that the relief sought in paragraph 6 of the notice of motion be dismissed. That brings me to the second topic, the challenge to the Assembly's 13 December 2022 decision. You will have seen that my clients do not engage with the merits of the applicant's challenge to that resolution. We've left that to the ANC and to the President to do. What we focus on is why in our submission the challenge has been brought fatally late. I've listened to the debate this morning between the members of the court and my learned friend, Mr. Prima, for the EFF in particular. And I don't intend to traverse everything in this regard, because in my respectful submission, the issues have been very fully ventilated. I do, however, wish to deal with a couple of points on which we believe we can contribute to this court's adjudication of this difficulty. The first concerns the form of the relief which has been sought and the submissions relevant to the delay issue which you have heard based on the form. The applicants have cast their challenge as a series of declaratives, and we submit that despite that, if one looks at the notice of motion as a whole, the relevant paragraphs, the substance as opposed to the form of the relief that they are seeking, or at least that the EFF is seeking at any rate, because my learned friend Mr. Katz said they no longer persist with paragraphs 3, 4 and 5 at the ATM. But certainly as far as the EFF is concerned, what is the substance? They're asking this court to exercise judicial review of the impugned decision and to grant consequential relief. If one looks at paragraph 5, you will see it's headed pursuant to Pres 1 to 4 above. They want substitution relief, a la Trincon. Alternatively, they want the matter referred back to the Assembly to vote on the panel's report de novo. So they're seeking judicial review and the setting aside of the decision, coupled with either a substitution or a referral back. That's the substance of the case, leaving aside the form. And if you're with us on that, then there is no debate, really, or can be no debate, that the delay rule applies. This court has made it clear in numerous cases that the delay rule applies to proceedings for judicial review. I refer, for example, to Kumalo, the famous Kumalo decision, 2014 5 SA 579 Constitutional Court at paragraphs 49 and following. Yes, that was a so-called state self-review application, but it was an application for judicial review, and the delay rule was clearly articulated and elaborated on and applied to the decisions at question in that case. But even if I'm wrong on the submissions that I've just made about the substance of the relief being judicial review, setting aside, and then one of these two alternatives, we submit firstly that declaratory relief is a discretionary remedy. And in that regard, we would remind the court that the very first authority cited by Justice Conradi in the Naptosa judgment on which the EFF relies. That's 2001, Volume 2, Essay 112, Cape. And one sees this at 124I. The very first authority is the judgment of this court in JT Publishing, 97.3, Essay 514, Constitutional Court, a case concerning a situation where there was a constitutional challenge to an Act of Parliament, which had been repealed by another Act of Parliament, although that Act had not yet been put into operation, and what the court should do about that. And paragraph 15, in that early decision, really pulls the rug with respect under the EFF's whole argument based on declaratory proceedings and delay. I'm going to couple it with the judgment of the SCA in a case called Somanko, but the bottom line is this, and perhaps I should just read the relevant portions of paragraph 15. The reversal of the decision reached in this court, in the court below, brings duly before us the claim for a declaratory order which the applicants wish us to grant on the constitutional issues presented by them. That does not necessarily mean, however, that we are now bound to resolve those issues. Whether we should say anything at all about them must be settled first. I interpose that inquiry because a declaratory order is a discretionary remedy, in the sense that the claim lodged by an interested party for such an order doesn't in itself oblige the court handling the matter to respond to the question which it poses, even when that looks like being capable of a ready answer. A corollary is the judicial policy governing the discretion thus vested in courts, a well-established and uniformly observed policy which directs them not to exercise it in favour of deciding points that are merely abstract, academic or hypothetical. I see no reason why this new court of ours should not adhere to a rule that sounds so sensible. And later on, in connection with section 85 of the interim constitution, which is the equivalent of 172(1)A of the new one, the court continued, a further word or two had better be said on the topic before I leave it. Section 9085 admittedly enjoins us to declare that a law is invalid once we found it to be inconsistent with the Constitution. But the requirement doesn't mean that we're compelled to determine the anterior issue of inconsistency when, owing to its wholly abstract, academic or hypothetical nature, it should have such in a given case are going into it that it can produce no concrete or tangible result. Indeed, none whatsoever beyond the bare declaration. And the court will know that our basic problem with the lateness is that the Sixth Parliament came to an end, with it all the business before the Sixth Parliament. The composition of the Seventh Parliament elected on the 29th of May is wholly different to the Sixth Parliament, and there can therefore be no resuscitation of this motion without doing a violence to that very fundamental part of our democracy. Every 5 years we have a general election and a new National Assembly is elected. As Justice Ngcobo, I think, pointed out to my learned friend, it's very differently constituted. So we are in a situation of impossibility, mootness. We're in a situation, a Van Wyk and Unitas Hospital situation, as Justice Majid pointed out to my learned friend. The applicants have delayed so long that it is impossible to do anything other than give a declaration in the air in this case. That is not what the jurisprudence of this court tolerates. Both JT Publishing and Van Wyk and Unitas Hospital.
Thank you, Mr. Breitenbach. Questions, colleagues?
Mr. Breitenbach, two issues from my side. The first is that in dealing with the sort of first ground of attack in relation to 129I, you concluded that this court has previously said that it will not prescribe the content of the rules the National Assembly adopts to hold the President accountable, and that the Assembly must determine our best, and that should be left to the National Assembly. But But would you accept that there's a caveat to that proposition, that ultimately it must enable the National Assembly to hold the President accountable? Because if those rules fall short, then a court is entitled to say these rules don't do what they purport to do or what they're required to do constitutionally. Do you accept that?
Unreservedly.
Now, in the light of that, you've suggested that Rule 129I, which deals with the consideration and the referral of the panel report, and in particular subsection 3 thereof, must be read to incorporate certain factors that the National Assembly must take into account. But when you read the rule, on the face of it, it simply says, in the event the Assembly resolves that an inquiry be proceeded with. So it's silent on what factors the Assembly may consider. And anybody reading that may justifiably conclude that the Assembly has a wide, unfettered discretion to do with the report as it pleases. And your suggestion that the Assembly is entitled to question the report or obliged to question and to critique the report on a reasonable basis may not find accommodation in the rule as it stands. And does that not lead to some credence in the argument that it is left really to the total discretion of the Assembly, which could undermine, as it were, any attempt to hold the President accountable in the absence of fettering that discretion?
The answer that I've given to that, and in summary, is that one must, of course, read the rule in its context, and specifically in the sequence of the steps that have to be taken. And we know from the preceding rules, 129G in particular, that the relevant context is there must be consideration of the motion, the information in support of the motion by a specialist independent panel who must advise the committee on whether or not there is sufficient evidence to show or to substantiate the allegations in the motion. And I could only add to this by posing the following rhetorical question. If it were not to direct the Assembly's mind to what we consider to be the, and have submitted as the relevant question for the Assembly to decide whether there is sufficient evidence, why would the rule have required an independent panel to conduct the preliminary inquiry and to give the advice on that question to the Assembly? And the answer with respect to that is because a decision to refer to the impeachment committee is essentially one to initiate a process, a trial type process on the charges in the motion. And that's the link between what goes before and what goes after. And the seriousness of the matter, as was pointed out to my colleagues this morning, but more importantly, the deep seriousness for the country as a whole of having their president on trial while the president is also the president of the country with all of the onerous responsibilities that come with that office, require, as the rule read, the set of rules read as a whole indicate that only be done where there is sufficient evidence of, for example, serious misconduct.
Sure. I accept that, and the rule is quite detailed in setting out how the panel must go about its work and at what level of sufficiency it must arrive at to render its conclusion sustainable. But it's worryingly silent on what the responsibility of the National Assembly is. And as, if I may say so, reasonable people, we seek to read into Sub-Rule 3 this requirement, but it's not there. And I want to establish from you, are you saying that if the panel produces a flawless report, a report that can't be faulted, that is in full compliance with 129, the Assembly would be obliged to accept the recommendation? Or are you saying that even in the face of such a report, the Assembly still has a wider discretion not to, for other reasons? Let's assume the report is flawless, but the impeachment of the president will result in the collapse of democracy and anarchy in the country. Will that be relevant?
On my approach, the approach which I've indicated, and I'm just going to break your question into two portions if you don't mind. The first is that the decisional reference do not include the other factors which bear on, let's say, the body politic and the health of South Africa Inc. If I could corporatize us for a moment. But how the rule deals with that is to require us as a country to run that risk only if there is sufficient evidence that the president may be guilty of the charges proffered against him or her. So the decisional referent remains sufficiency of evidence, and one does not take those other factors into account. And as painful as it may be and disruptive as it may be, if that is the Assembly's judgment at that juncture, then there must be a trial. The second component of your question goes to whether the Assembly is bound to accept the recommendation in what you've styled a flawless report. And the answer to that is the Assembly exercising public power must act rationally. So it is bound to take a rational decision. And if it engages with the question, the ultimate question, is there sufficient evidence to put the president on trial, and reaches a different conclusion to the panel, in other words, does not accept the advice, but it, in a rational manner deals with that, then that will pass muster. Because, as this court has repeatedly emphasized, it is the National Assembly which ultimately controls this process. And with the greatest respect, the standard cannot be higher than that. But of course, where one is acting irrationally or for ulterior purposes, which would be a species of bad faith, mala fides, arbitrarily, then of course the courts would be entitled to intervene, and the ordinary remedies, or perhaps not even the ordinary, the full panoply of remedies which are at the disposal of this court as the ultimate arbiter of these matters in instances of abuse of power, because that is what we would really be talking about, would be available. And may I just make one last point in response to your line of questioning, Justice Colopin? This case, of course, and this aspect of the case is not subject to the delay objection that we have raised. And so this court is going to have to engage with these difficult matters. And of course, the court can, in its judgment, if it accepts these submissions that I've made, can say authoritatively what the decisional referents are under section for a Rule 129I3 decision, and can also warn against abuses of power and the fact that abuses of the power will fall foul of the requirements of rational, non-arbitrary and good faith decision-making which our Constitution imposes in all instances where public power is exercised. So to the extent that you and others on the bench may be concerned about the lack of enumeration of the relevant factors in the discretion conferring provision itself, that may be dealt with in the judgment.
Thank you, Mr. Pitt. And finally, if we go in that direction, you don't make any submissions on the merits, not so?
I do not.
Thank you.
Breitenbach, and I think some of this follows from the questions from my brother Justice Colopin. The rules that we're dealing with, does it permit the National Assembly to exercise an unfettered discretion to vote down a panel report for any reason that the Assembly feels strong enough or compelling enough?
In short, no. Now, all of the reasons that I've given, no. It has to consider the sufficiency of evidence.
And isn't that the nub of the question before this court?
Yes.
And that's the applicant's argument that in this instance, there should have been a further step. And if the rules don't provide for that, is there not a difficulty with the rules? And do the rules then comply with what this court said in EFF2?
If the court accepts my submission that what the Assembly has to consider is whether there is or whether there is not sufficient evidence to put the President on trial, guided by, but not bound by the panel's report, then with respect, there isn't a problem, because that's what the rules properly interpreted require. I know that the architecture of the debate between the applicants on the one hand and the President and the ANC on the other hand is such that they cross swords on that question. I know also that criticism has been directed in this court to the panel's report. It asked and answered the wrong question. We've heard a discussion about that today as one of the points of criticism. But coming back to what Justice Coleman asked me, even assuming an impeccable report, something where no such criticisms could be leveled, there aren't difficulties with the nomenclature, perhaps indicative of errors of law made by those compiling it. Ultimately, in this important matter, as this court has held, it is for the Assembly to craft for itself a process which includes this initial sifting mechanism. There are actually two of them, as we know.
But if the process that's been crafted by the Assembly does not meet the objective and does not meet the standard and the criteria that this court set out in EFF2, is there not a problem?
Yes, I undoubtedly and unreservedly accept that. But the if is not satisfied in this case. These rules are fit for purpose. The President will only be put on trial if the Assembly decides that there is sufficient evidence to warrant that.
Isn't it problematic that the rules give the Assembly an unfettered discretion in that regard and to determine that question? And shouldn't the rules be tempered or the discretion be tempered?
That's such a difficult question, because ultimately the reason for the difficulty is this, is that the rules are made by the Assembly. So the Assembly, what the suggestion is that the Assembly should specify in advance, enumerate, somehow elaborate in a way that will assist decision-making on a case-by-case basis. And that's beyond the definitions of serious misconduct, etc., that are already there. So it must specify that in advance. And the difficulty that I'm pointing to, Justice Turon, is that, and I suppose this is what the court's going to have to grapple with, having left it at the sufficient evidence criterion, and then allowing the Assembly on a case-by-case basis to relate the sufficient evidence to the grounds as defined in the opening part of this new section of the rules: serious misconduct, serious violation of the Constitution of the law. Whether the Assembly in advance has gone far enough of saying to the Assembly how in the future it should deal with the screening function. And it's really a question of when the Assembly speaks, and I suppose it boils down to this. Does EFF2 require that the Assembly must say more, elaborate on this sufficient evidence inquiry criterion in advance? I would submit it doesn't, and one of the reasons why is that it's not very different from the standard which prosecutors have to interpret and apply in deciding whether or not to prosecute. And it's never been suggested that we need that.
I don't mean to cut you short, but I am very aware of time. If this court finds that the discretion that the National Assembly has given to itself in terms of the rules is too wide or it's unfettered, what would your suggestion be on how to temper that discretion?
I must honestly say, I suppose one would have to, I would say that one would have to, in order to respect the separation of powers, and also to the fact that I'm not the National Assembly, although I represent them in this case, what I would say is that the court would have to identify the respects in which...
I'm asking for the views of the party that you represent.
No, I understand that.
To assist this court.
I understand that. I respectfully submit that the proper approach would be for the court to identify the problems and then to leave it to the Assembly to consider and craft a remedy, a remedial rule, which would address those problems. I do, and I say this with the utmost respect, believe that, that in cases of this kind, where the apex court is in a dialogue with the Assembly, not here in this court, but in your judgment, that one has to be mindful of the separation of powers constraints. And for that reason, with great respect to my learned friends, the sort of substitution type relief is really a non-starter in a case of this kind.
Made a note of one of your earlier responses to my questions, and I can't read my own writing now. It says, I think you said we must be guarded. We were talking about the report. On the one hand, we must be guarded by the report, and on the other, Parliament is not bound to accept the report. I think you said something along those lines. So what is the status of the report then? What is the value of the report?
It is advice by an expert body, people who, if one looks at 129E1, the requirements for the composition of the panel, 3 fit and proper, competent, experienced and respected South Africans, which may include a judge, and who collectively possess the necessary legal competence and experience. So one has a report by a committee of legal experts, which must consider the information which is submitted together with the motion, which may afford any member to place other relevant written material before it, which must provide the President with everything and get the President's response, and must then weigh it and make findings as to whether there is sufficient evidence, and make a recommendation and give reasons therefore. And so it is a quite detailed set
I'm
of
sorry to
terms
interrupt you once again, but surely it has to be more than advice, because the Speaker could well have gone to legal counsel, could well have gone to attorneys and officials employed in the department. The National Assembly can do the same for advice. It should be a little bit more than an advisory opinion.
In the
Don't you think?
in the answer that I'll give to that is it's undoubtedly clear from the rules read as a whole that it is an advisory body. Otherwise, one could not explain Rule 129P2. The surely in your question goes to something else, and that is whether it should be more than advice. But of course, I've made my submissions on that. If the panel's findings and recommendation are binding on the Assembly, then you will be taking, if that is the finding of this court, you'll be taking out of the hands of the Assembly the assessment of whether there is sufficient evidence for the President to go on trial. And we submit that is inconsistent with Section 55(2) of the Constitution. We submit it is any such order with respect would entail an infringement of the principle of separation of powers.
Now, you accepted earlier in our discussion, Mr. Breitenbach, that the National Assembly's discretion should not be unfettered.
Sorry, would you mind repeating?
The National Assembly's discretion should not be unfettered. You accepted that.
It is not unfettered as a matter of interpretation.
And if this court were to say so, that would not be a breach of the separation of powers doctrine.
It would not, because the court would be interpreting a document and applying the ordinary rules of interpretation as developed in Cool, Ideas and Hubbard and the cases following it, saying this is what it means. You, the Assembly, have written this document, and it means that you have to consider the sufficiency of evidence.
Yes, my last question relates to sufficiency of evidence, and I apologize if this has been asked of you or of your colleagues before. What is the appropriate standard that the panel should have used? Sufficiency of evidence, prima facie case, or is it either one of those two? Is there a distinction between the two? If there is, what is the distinction?
So it's best to, although this falls more properly in the province of my colleagues, Mr. Budlander and Mr. Ngcobo, I would obviously draw the court's attention to the precise wording of the relevant rules, which is 129(1)A and 129, so that's 129A, 1A, and 129G1B. 129(1)A refers to a clearly formulated and substantiated charge on grounds specified in Section 89, which must prima facie show. And my understanding of that and my submission is that one reads the charge and you ask yourself if all of the factual allegations on which it is based are correct. Does this show serious misconduct, serious violation of the law, etc.? And one can liken it to the scrutiny that we do every day as lawyers, where you look at a set of statement of claim or particulars of claim or a plea, and you read it and you ask yourself, do the facts alleged by the pleader prima facie, in other words, established on its face, but if established by the evidence supporting it, lead to the legal conclusion and the relief sought. It's an exception type assessment. So that's what's required of the speaker. Very different as a line of questioning this morning from the court to my learned friend, Mr. Prima. The wording here is a recommend, and this is now 129G1B, a recommendation to the speaker whether sufficient evidence exists. Now one looks at the underlying information, the information attached to the motion, any information which the panel in its discretion has sought from members, the President's reason, and you ask yourself two questions. Does this point to the existence of evidence? Not information, but evidence. In other words, oral testimony or documentary evidence which can be adduced as proof. And the second issue, which is one on which evaluate, and it's an evaluative question, not an admissibility issue, is the sufficiency of that evidence. And it is and my reticence, perhaps you would say egg dancing, around elaborating on that, is that it is something which requires a case-by-case and fact-specific assessment in any case. My learned colleagues will address whether Mr. Lamola and others got that wrong in their assessment of this particular matter.
Thank you, Mr. Breitenbach. Thank you, Chief Justice.
Mr. Breitenbach, just two quick questions. Just apropos what you've just said to Justice Theron, surely this panel is just a little more than an advisory body. It is surely, as the rules itself say, it's an initial inquiry, but it's non-binding on Parliament, the Assembly.
Certainly, except that to the extent that its inquiry entails information gathering in its discretion from members, it does determine the record, and it goes beyond that. In other words, the mechanism is, it's not a committee of Parliament or the NA itself which must undertake the screening function. It's left to senior people with the necessary legal competence and experience to do that. I accept that. But when it comes to its findings and the reasons for its findings and its recommendation, the rule is clear. It must substantiate what it says and recommends. But it is up to the Assembly to decide whether or not to do what is recommended. Let's assume for counterfactual that the recommendation was not to proceed to an impeachment inquiry, whether or not to follow that. And it's in that sense that I refer to it as an advisory body. It doesn't have decision-making power, and specifically the power to take the decision in question here, namely, there shall or shall not be an impeachment Section 89 inquiry.
And then just lastly, just a quick question. As I understand it, you don't quibble with exclusive jurisdiction on this matter. Thank you. Thank you, CJ.
Mr. Breitenbach, I have one niggling issue. I hope you'll help me. Is it correct to say, for as long as you have the majority in Parliament or in National Assembly, it doesn't matter whether the report is prima facie or the report mentioned prima facie or sufficient evidence? Put it differently, if the report that we have now had stated that it's based on sufficient evidence, it could still have been defeated on the basis of the majority vote. If that is the case, then there is a problem with the rule. Am I right to make that assumption?
With respect, I do not think you're correct for this reason.
Where am I wrong?
This court has said in EFF 1 and elsewhere that when voting on matters like these, it is what prevails is the responsibilities that members have as members of Parliament to the constitutional project. And specifically in this instance, they must show fidelity to the rules which they themselves have crafted following the judgment in EFF 2, which require a decision on our submission as to whether there is sufficient evidence or not. It does not follow from that in our system of constitutional democracy, where one votes for political parties who determine who represents them in the National Assembly, that parties may not caucus and that they may not have this debate, let's call it the sufficiency of evidence debate, behind closed doors before they have debate in open Parliament. It is a matter which they are entitled as political parties, particularly the majority political party, but equally it goes for parties which are in the minority, to assess this question and to see whether there is agreement among them. Where it becomes difficult is if the whip is applied to members, and in the sense that members are told that they must go with the decision of the majority of the caucus on pain of being expelled from the party. If that has the result that members who dissent on that question do not vote with the party simply because of the whip, in other words, they do what this court has said they mustn't do, which is show fidelity to the party and not to the Constitution when dealing with important matters such as these, then that would be a problem. The question in this case, which my colleagues for the President and particularly the ANC will be dealing with, because it is a challenge frontally or squarely raised, is whether the evidence in this case shows that to be the case.
My second question is, does the issue relating to the sufficiency of evidence falls within your brief, or should it be left to Mr. Padlender and Mr. Ngcobo?
On the facts?
Yeah.
My client is not engaged with the merits. They've left it to the political party and to the President, the ANC and the President to deal with. So I'm unprepared to deal with that, and if you don't mind, I'll pass that hot potato to my left and to my right.
Perhaps before you do that, maybe they can eavesdrop into my question. If the test, as we have come to know, and there's a debate around it, it's sufficiency of evidence, and we know that the panel does not conduct oral hearings. Let's try and step into the shoes or the boots of the panel as to how can they make a determination as to whether this evidence is prima facie and this evidence is sufficient.
So
it's looking at the papers, statements and whatever.
Yes.
Is it something that you are prepared to answer, or I can leave it for your colleagues?
All that I would say, and my colleagues can correct me if they think I'm wrong, is the following.
I don't want you to muddy the waters.
No, I won't. If the question which is put to you, does sufficient evidence exist to show that the President has committed serious violation of the Constitution X? The first thing you ask yourself as you look at this information, you ask yourself, does it point to the existence of evidence? Is there a statement from Mr. Jones, for instance, a signed statement from a particular person who was an eyewitness, or can give relevant evidence to this impeachment committee in due course? Is there a document, the contents of which, if it's authentic, tend to show that, and which, if it's admitted, provide evidence? So that is why you have people who have to be experienced lawyers to look at this, because it is an assessment. It's a much more difficult an assessment that needs to be done at a screening level, but not that different from what prosecutors have to do before they decide whether or not to prosecute. As you look at the information that you have, you ask yourself, firstly, as I've said, does it point to the existence of evidence that can be adduced? And secondly, then the harder part oftentimes is the evaluation of the sufficiency of that evidence. Is it sufficient to run a case, to prove a case, which will show that?
Thank you, Sisha.
Mr. Breitenbach, just one question. Seeing the purpose of these rules, that is to hold the executive, whoever that may be, accountable, how will it encroach on the separation of powers if this court gives some guidance to factors that the National Assembly should take into consideration when considering the process?
Let me make it plain that the separation of powers concern which I have raised derives from a series of judgments by this court, particularly the EFF 1 and EFF 2, in which the court has pointed out the problems with an existing, in the first case it was with what happened in relation to the public protector's report, or what didn't happen more specifically. And in the second one, it was with the existing rules, the gap in the existing rule. I do not submit that a judgment by this court in which it elaborates on what's relevant and what would not be relevant when exercising the power under 129I3 would necessarily entail an infringement of separation of powers. Where one runs into difficulty is when this court starts prescribing the details of the mechanism. And the thrust of the submissions that I've made today is that the rules say enough. I do take the point which Justice Collapen has made, that the rule on its face doesn't indicate, and one has to look at the contextual factors and its purpose in order to arrive at the point that I've done in my submissions. But if your question is, if the court were to say that, and to say, well, that's relevant and that's what must be considered, and what you cannot do is take into account factors which do not go to the sufficiency of evidence, would that be an infringement of separation of powers? I don't believe that would be.
Well, one can go even further. This court can give guidance and then refer it back to the National Assembly to take those principles into consideration. I think then we've got a clear, then this court would have executed its duty and also respected the separation of powers.
Possible, but unfortunately, when this court speaks, its guidance, and understandably, is taken and must be taken as the law of the Medes and Persians, and it must be implemented because of the comity between the branches of government. And all that I would say in response to your question is that when one starts giving guidance as to matters of detail, one must bear in mind the Section 55(2) of the Constitution.
Thank you, Mr. Brayton.
Thank you very much, Mr. Breitenbach. Mr. President.
Justice, would you give us a minute to just move sideways so that our colleague...
May it please the court, I'm going to deal with 6 matters, which are the following. Firstly, the question of delay. Secondly, exclusive jurisdiction. Thirdly, the fundamental error of the panel. Fourthly, sufficient evidence, or rather evidence. Fifthly, bad faith. And sixthly, the reasons given by Minister Lamola. If I have time, I want to briefly respond to what I submit is an underlying flaw in the approach of our learned friend, Mr. Katz. So to start with delay, in an attempt to avoid the obvious problem of delay, the EFF says this is not a review, it's an application for a declaration. As Justice Majid pointed out, that doesn't actually get them off the hook. But in any event, it's wrong. It is a review, and it's a review for three reasons. Firstly, a declaration is one of the forms of review, forms of remedy in judicial review. It's well accepted. It has been forever. A declaration is a remedy for a judicial review. That's, if you look at Baxter's book on administrative law, you see, look at the remedies that he lists, you'll find declarations there. Look at the Smith's book on judicial review, you'll find declarations there. Look at Wade and Forsyth's book on administrative law, and you'll find they too, when they discuss remedies on a review, explain why a declaration is often a particularly effective remedy.